Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Trump v. United States. In this case, the court considered this issue. Does a former president enjoy presidential immunity from criminal prosecution for conduct alleged to involve official acts during his tenure in office, and if so, to what extent? The case was decided on July 1, 2024. The Supreme Court held that a former U.S. president has absolute immunity from criminal prosecution for actions within his conclusive and preclusive constitutional authority, at least presumptive immunity from prosecution for all his official acts, and no immunity for unofficial acts. Chief Justice Roberts, writing for the court majority, concluded that a former president has some immunity from criminal prosecution for official acts during his tenure in office. This immunity stems primarily from constitutional separation of powers principles and precedents recognizing similar immunities in civil contexts. The president has absolute immunity from prosecution for actions taken pursuant to his exclusive constitutional powers, such as pardoning offenses or removing executive officers. This absolute immunity exists because Congress cannot criminalize, and courts cannot review, the president's exercise of these core constitutional authorities. For official actions outside the president's exclusive constitutional powers, there is at least a presumptive immunity from prosecution. This presumptive immunity is rooted in the need to ensure the president can perform his duties without undue caution or distraction, as established in cases like Nixon v. Fitzgerald. The government may attempt to rebut this presumption by demonstrating that prosecution would not unduly intrude on executive functions. However, evidence of immune official acts cannot be used to prove liability for unofficial acts, as this would undermine the purpose of the immunity. Finally, drawing on Clinton v. Jones, the court affirmed that the president has no immunity for actions taken in an unofficial or personal capacity. To apply this framework, courts must carefully analyze alleged conduct to determine whether it qualifies as official or unofficial. The court rejected both Trump's argument for broader immunity absent impeachment and conviction, and the government's contention that the president has no immunity from criminal prosecution whatsoever. Instead, it established a nuanced approach requiring case-by-case analysis of presidential conduct to determine the applicable level of immunity, if any. Justice Clarence Thomas wrote a separate concurrence to highlight that he believes the special counsel's prosecution of Trump may be unconstitutional because there are serious questions about whether the office of the special counsel was properly established by law as required by the Constitution's Appointments Clause. Justice Amy Coney Barrett wrote a separate opinion concurring in part to argue that rather than framing the issue as immunity, the court should have adopted a two-step analysis for assessing the validity of criminal charges against a president for official acts, first determining if the relevant statute applies to the president's conduct, and then evaluating whether prosecuting the president under that statute would unconstitutionally intrude on executive power. Justice Sonia Sotomayor dissented because she believes the majority's decision to grant former presidents broad immunity from criminal prosecution for official acts is unjustified by constitutional text, history, or precedent, and dangerously places the president above the law. Justice Ketanji Brown Jackson dissented because she believes the majority's creation of a new presidential accountability model that sometimes exempts presidents from criminal law for official acts fundamentally alters the balance of power, undermines the rule of law, and risks incentivizing presidential abuses of power. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Chief Justice Roberts delivered the opinion of the court. This case concerns the federal indictment of a former president of the United States for conduct alleged to involve official acts during his tenure in office. We consider the scope of a president's immunity from criminal prosecution. From January 2017 until January 2021, Donald J. Trump served as President of the United States. On August 1, 2023, a federal grand jury indicted him on 4 counts for conduct that occurred during his presidency following the November 2020 election. The indictment alleged that after losing that election, Trump conspired to overturn it by spreading knowingly false claims of election fraud to obstruct the collecting, counting, and certifying of the election results. According to the indictment, Trump advanced his goal through 5 primary means. First, he and his co-conspirators used knowingly false claims of election fraud to get state legislators and election officials to change electoral votes for Trump's opponent, Joseph R. Biden Jr., to electoral votes for Trump. Second, Trump and his co-conspirators organized fraudulent slates of electors in 7 targeted states and caused these fraudulent electors to transmit their false certificates to the vice president and other government officials to be counted at the certification proceeding on January 6. Third, Trump and his co-conspirators attempted to use the Justice Department to conduct sham election crime investigations and to send a letter to the targeted states that falsely claimed that the Justice Department had identified significant concerns that may have impacted the election outcome. Fourth, Trump and his co-conspirators attempted to persuade the vice president to use his ceremonial role at the January 6 certification proceeding to fraudulently alter the election results. And when that failed, on the morning of January 6, they repeated knowingly false claims of election fraud to gathered supporters, falsely told them that the vice president had the authority to and might alter the election results, and directed them to the Capitol to obstruct the certification proceeding. Fifth, when a large and angry crowd violently attacked the Capitol and halted the proceeding, Trump and his co-conspirators exploited the disruption by redoubling efforts to levy false claims of election fraud and convince members of Congress to further delay the certification. Based on this alleged conduct, the indictment charged Trump with conspiracy to defraud the United States, conspiracy to obstruct an official proceeding, obstruction of an attempt to obstruct an official proceeding, and conspiracy against rights. Trump moved to dismiss the indictment based on presidential immunity. In his view, the conduct alleged in the indictment, properly characterized, was that while he was president he made public statements about the administration of the federal election, communicated with senior Justice Department officials about investigating election fraud and about choosing the leadership of the department, communicated with state officials about the administration of the federal election and their exercise of official duties with respect to it, communicated with the vice president and with members of Congress about the exercise of their official duties regarding the election certification, and authorized or directed others to organize contingent slates of electors in furtherance of his attempts to convince the vice president to exercise his official authority in a manner advocated for by President Trump. Trump argued that all of the indictment's allegations fell within the core of his official duties, and he contended that a president has absolute immunity from criminal prosecution for actions performed within the outer perimeter of his official responsibilities, to ensure that he can undertake the especially sensitive duties of his office with bold and unhesitating action. The district court denied the motion to dismiss, holding that former presidents do not possess absolute federal criminal immunity for any acts committed while in office. The district court recognized that the president is immune from damages liability in civil cases, to protect against the chilling effect such exposure might have on the carrying out of his responsibilities. But it reasoned that the possibility of vexatious post-presidency litigation is much reduced in the criminal context in light of the robust procedural safeguards attendant to federal criminal prosecutions. The district court declined to decide whether the indicted conduct involved official acts. The D.C. Circuit affirmed. Citing Marbury v. Madison, the court distinguished between two kinds of official acts, discretionary and ministerial. It observed that although discretionary acts are only politically examinable, the judiciary has the power to hear cases involving ministerial acts that an officer is directed to perform by the legislature. From this distinction, the D.C. Circuit concluded that the separation of powers doctrine, as expounded in Marbury and its progeny, necessarily permits the judiciary to oversee the federal criminal prosecution of a former president for his official acts, because the fact of the prosecution means that the former president has allegedly acted in defiance of the Congress's laws. In the court's view, the fact that Trump's actions allegedly violated generally applicable criminal laws meant that those actions were not properly within the scope of his lawful discretion. The D.C. Circuit thus concluded that Trump had no structural immunity from the charges in the indictment. Like the district court, the D.C. Circuit declined to analyze the actions described in the indictment to determine whether they involved official acts. We granted certiorari to consider the following question: whether and if so to what extent does a former president enjoy presidential immunity from criminal prosecution for conduct alleged to involve official acts during his tenure in office? This case is the first criminal prosecution in our nation's history of a former president for actions taken during his presidency. We are called upon to consider whether and under what circumstances such a prosecution may proceed. Doing so requires careful assessment of the scope of presidential power under the Constitution. We undertake that responsibility conscious that we must not confuse the issue of a power's validity with the cause it is invoked to promote, but must instead focus on the enduring consequences upon the balanced power structure of our republic. The parties before us do not dispute that a former president can be subject to criminal prosecution for unofficial acts committed while in office. They also agree that some of the conduct described in the indictment includes actions taken by Trump in his unofficial capacity. They disagree, however, about whether a former president can be prosecuted for his official actions. Trump contends that just as a president is absolutely immune from civil damages liability for acts within the outer perimeter of his official responsibilities, he must be absolutely immune from criminal prosecution for such acts. And Trump argues that the bulk of the indictment's allegations involve conduct in his official capacity as president. Although the government agrees that some official actions are included in the indictment's allegations, it maintains that a former president does not enjoy immunity from criminal prosecution for any actions, regardless of how they are characterized. We conclude that under our constitutional structure of separated powers, The nature of presidential power requires that a former president have some immunity from criminal prosecution for official acts during his tenure in office. At least with respect to the president's exercise of his core constitutional powers, this immunity must be absolute. As for his remaining official actions, he is also entitled to immunity. At the current stage of proceedings in this case, however, we need not and do not decide whether that immunity must be absolute, or instead whether a presumptive immunity is sufficient. Article 2 of the Constitution provides that the executive power shall be vested in a President of the United States of America. The President's duties are of unrivaled gravity and breadth. They include, for instance, commanding the armed forces of the United States, granting reprieves and pardons for offenses against the United States, and appointing public ministers and consuls, the justices of this court, and officers of the United States. He also has important foreign relations responsibilities, making treaties, appointing ambassadors, recognizing foreign governments, meeting foreign leaders, overseeing international diplomacy and intelligence gathering, and managing matters related to terrorism, trade, and immigration. Domestically, he must take care that the laws be faithfully executed, and he bears responsibility for the actions of the many departments and agencies within the executive branch. He also plays a role in lawmaking by recommending to Congress the measures he thinks wise and signing or vetoing the bills Congress passes. No matter the context, the President's authority to act necessarily stems either from an act of Congress or from the Constitution itself. In the latter case, the President's authority is sometimes conclusive and preclusive. When the President exercises such authority, he may act even when the measures he takes are incompatible with the expressed or implied will of Congress. The exclusive constitutional authority of the President disables the Congress from acting upon the subject, and the courts have no power to control the President's discretion when he acts pursuant to the powers invested exclusively in him by the Constitution. If the President claims authority to act but in fact exercises mere individual will and authority without law, the courts may say so. In Youngstown, for instance, we held that President Truman exceeded his constitutional authority when he seized most of the nation's steel mills, but once it is determined that the President acted within the scope of his exclusive authority, his discretion in exercising such authority cannot be subject to further judicial examination. The Constitution, for example, vests the power to grant reprieves and pardons for offenses against the United States and the President. During and after the Civil War, President Lincoln offered a full pardon, with restoration of property rights, to anyone who had engaged in the rebellion but agreed to take an oath of allegiance to the Union. But in 1870, Congress enacted a provision that prohibited using the President's pardon as evidence of restoration of property rights. Chief Justice Chase held the provision unconstitutional because it impaired the effect of a pardon, and thus infringed the constitutional power of the executive. To the executive alone is entrusted the power of pardon, and the legislature cannot change the effect of such a pardon any more than the executive can change a law. The President's authority to pardon, in other words, is conclusive and preclusive, disabling the Congress from acting upon the subject. Some of the President's other constitutional powers also fit that description. The President's power to remove, and thus supervise, those who wield executive power on his behalf, for instance, follows from the text of Article 2. We have thus held that Congress lacks authority to control the President's unrestricted power of removal with respect to executive officers of the United States whom he has appointed. The power to control recognition determinations of foreign countries is likewise an exclusive power of the President. Congressional commands contrary to the President's recognition determinations are thus invalid. Congress cannot act on, and courts cannot examine, the President's actions on subjects within his conclusive and preclusive constitutional authority. It follows that an act of Congress, either a specific one targeted at the President or a generally applicable one, may not criminalize the President's actions within his exclusive constitutional power. Neither may the courts adjudicate a criminal prosecution that examines such presidential actions. We thus conclude that the President is absolutely immune from criminal prosecution for conduct within his exclusive sphere of constitutional authority. But of course not all of the President's official acts fall within his conclusive and preclusive authority. As Justice Robert Jackson recognized in Youngstown, the President sometimes acts pursuant to an express or implied authorization of Congress, or in a zone of twilight where he and Congress may have concurrent authority. The reasons that justify the President's absolute immunity from criminal prosecution for acts within the scope of his exclusive authority, therefore do not extend to conduct in areas where his authority is shared with Congress. We recognize that only a limited number of our prior decisions guide determination of the President's immunity in this context. That is because proceedings directly involving a President have been uncommon in our nation, and decisions of the court in this area have accordingly been rare and episodic. To resolve the matter, therefore, we look primarily to the framers' design of the presidency within the separation of powers. Our precedent on presidential immunity in the civil context, and are criminal cases where a president resisted prosecutorial demands for documents. The president occupies a unique position in the constitutional scheme, as the only person who alone composes a branch of government. The framers sought to encourage energetic, vigorous, decisive, and speedy execution of the laws by placing in the hands of a single, constitutionally indispensable, individual the ultimate authority that, in respect to the other branches, the Constitution divides among many. They deemed an energetic executive essential to the protection of the community against foreign attacks, the steady administration of the laws, the protection of property, and the security of liberty. The purpose of a vigorous and energetic executive, they thought, was to ensure good government, for a feeble executive implies a feeble execution of the government. The framers accordingly vested the president with supervisory and policy responsibilities of utmost discretion and sensitivity. He must make the most sensitive and far-reaching decisions entrusted to any official under our constitutional system. There accordingly exists the greatest public interest in providing the president with the maximum ability to deal fearlessly and impartially with the duties of his office. Appreciating the unique risks to the effective functioning of government that arise when the president's energies are diverted by proceedings that might render him unduly cautious in the discharge of his official duties, we have recognized presidential immunities and privileges rooted in the constitutional tradition of the separation of powers and supported by our history. In Nixon v. Fitzgerald, for instance, we recognize that as a functionally mandated incident of his unique office, a former president is entitled to absolute immunity from damages liability predicated on his official acts. That case involved a terminated Air Force employee who sued former President Richard Nixon for damages, alleging that Nixon approved an Air Force reorganization that wrongfully led to his firing. In holding that Nixon was immune from that suit, our dominant concern was to avoid diversion of the president's attention during the decision-making process caused by needless worry as to the possibility of damages actions stemming from any particular official decision. The singular importance of the president's duties implicating matters likely to arouse the most intense feelings, coupled with the sheer prominence of his office, heightens the prospect of private damages suits that would threaten such diversion. We therefore concluded that the president must be absolutely immune from damages liability for acts within the outer perimeter of his official responsibility. By contrast, when prosecutors have sought evidence from the president, we have consistently rejected presidential claims of absolute immunity. For instance, during the treason trial of former Vice President Aaron Burr, Chief Justice Marshall rejected President Thomas Jefferson's claim that the president could not be subjected to a subpoena. Marshall reasoned that the law does not discriminate between the president and a private citizen. Because a president does not stand exempt from the general provisions of the Constitution, including the Sixth Amendment's guarantee that those accused shall have compulsory process for obtaining witnesses for their defense, a subpoena could issue. Marshall acknowledged, however, the existence of a privilege to withhold certain official papers that ought not on like ground to be forced into public view. And he noted that a court may not be required to proceed against the president as against an ordinary individual. Similarly, when a subpoena issued to President Nixon to produce certain tape recordings and documents relating to his conversations with aides and advisors, this court rejected his claim of absolute privilege, given the constitutional duty of the judicial branch to do justice in criminal prosecutions. But we simultaneously recognize the public interest in candid, objective, and even blunt or harsh opinions in presidential decision-making, as well as the need to protect communications between high government officials and those who advise and assist them in the performance of their manifold duties. Because the president's need for complete candor and objectivity from advisors calls for great deference from the courts, we held that a presumptive privilege protects presidential communications. That privilege, we explained, relates to the effective discharge of a president's powers. We thus deemed it fundamental to the operation of government and inextricably rooted in the separation of powers under the Constitution. Criminally prosecuting a president for official conduct undoubtedly poses a far greater threat of intrusion on the authority and functions of the executive branch than simply seeking evidence in his possession, as in Burr and Nixon. The danger is akin to, indeed greater than, what led us to recognize absolute presidential immunity from civil damages liability, that the president would be chilled from taking the bold and unhesitating action required of an independent executive. Although the president might be exposed to fewer criminal prosecutions than the range of civil damages suits that might be brought by various plaintiffs, the threat of trial, judgment, and imprisonment is a far greater deterrent. Potential criminal liability, and the peculiar public opprobrium that attaches to criminal proceedings, are plainly more likely to distort presidential decision-making than the potential payment of civil damages. The hesitation to execute the duties of his office fearlessly and fairly that might result when a president is making decisions under a pall of potential prosecution, raises unique risks to the effective functioning of government. A president inclined to take one course of action based on the public interest may instead opt for another, apprehensive that criminal penalties may befall him upon his departure from office. And if a former president's official acts are routinely subjected to scrutiny in criminal prosecutions, the independence of the executive branch may be significantly undermined. The framers' design of the presidency did not envision such counterproductive burdens on the vigor and energy of the executive. We must, however, recognize the countervailing interests at stake. Federal criminal laws seek to redress a wrong to the public as a whole, not just a wrong to the individual. There is therefore a compelling public interest in fair and effective law enforcement. The President, charged with enforcing federal criminal laws, is not above them. Chief Justice Marshall's decisions in Burr and our decision in Nixon recognize the distinct interests present in criminal prosecutions. Although Burr acknowledged that the President's official papers may be privileged and publicly unavailable, it did not grant him an absolute exemption from responding to subpoenas. Nixon likewise recognized a strong protection for the President's confidential communications, a presumptive privilege, but it did not entirely exempt him from providing evidence in criminal proceedings. Taking into account these competing considerations, we conclude that the separation of powers principles explicated in our precedent necessitate at least a presumptive immunity from criminal prosecution for a president's acts within the outer perimeter of his official responsibility. Such an immunity is required to safeguard the independence and effective functioning of the executive branch, and to enable the president to carry out his constitutional duties without undue caution. Indeed, if presumptive protection for the president is necessary to enable the effective discharge of his powers when a prosecutor merely seeks evidence of his official papers and communications, it is certainly necessary when the prosecutor seeks to charge, try, and imprison the president himself for his official actions. At a minimum, the president must therefore be immune from prosecution for an official act, unless the government can show that applying a criminal prohibition to that act would pose no dangers of intrusion on the authority and functions of the executive branch. But as we explain below, the current stage of the proceedings in this case does not require us to decide whether this immunity is presumptive or absolute. Because we need not decide that question today, we do not decide it. One case in more than 2 centuries does not afford enough experience to definitively and comprehensively determine the president's scope of immunity from criminal prosecution. As for a president's unofficial acts, there is no immunity. The principles we set out in Clinton v. Jones confirm as much. When Paula Jones brought a civil lawsuit against then-President Bill Clinton for acts he allegedly committed prior to his presidency, we rejected his argument that he enjoyed temporary immunity from the lawsuit while serving as president. Although presidential immunity is required for official actions to ensure that the president's decision-making is not distorted by the threat of future litigation stemming from those actions, that concern does not support immunity for unofficial conduct. The justifying purposes of the immunity we recognized in Fitzgerald, and the one we recognize today, are not that the president must be immune because he is the president. Rather, they are to ensure that the president can undertake his constitutionally designated functions effectively, free from undue pressures or distortions. It is the nature of the function performed, not the identity of the actor who performs it, that informs our immunity analysis. The separation of powers does not bar a prosecution predicated on the president's unofficial acts. Determining whether a former president is entitled to immunity from a particular prosecution requires applying the principles we have laid out to his conduct at issue. The first step is to distinguish his official from unofficial actions. In this case, however, no court has thus far considered how to draw that distinction, in general or with respect to the conduct alleged in particular. Despite the unprecedented nature of this case, and the very significant constitutional questions that it raises, the lower courts rendered their decisions on a highly expedited basis. Because those courts categorically rejected any form of presidential immunity, they did not analyze the conduct alleged in the indictment to decide which of it should be categorized as official and which unofficial. Neither party has briefed that issue before us, though they discussed it at oral argument in response to questions. And like the underlying immunity question, that categorization raises multiple unprecedented and momentous questions about the powers of the president and the limits of his authority under the Constitution. As we have noted, there is little pertinent precedent on those subjects to guide our review of this case, a case that we too are deciding on an expedited basis. Less than 5 months after we granted the government's request to construe Trump's emergency application for a stay as a petition for certiorari, grant that petition, and answer the consequential immunity question. Given all these circumstances, it is particularly incumbent upon us to be mindful of our frequent admonition that ours is a court of final review and not first view. Critical threshold issues in this case are how to differentiate between a president's official and unofficial actions, and how to do so with respect to the indictment's extensive and detailed allegations covering a broad range of conduct. We offer guidance on those issues below. Certain allegations, such as those involving Trump's discussions with the acting attorney general, are readily categorized in light of the nature of the president's official relationship to the office held by that individual. Other allegations, such as those involving Trump's interactions with the vice president, state officials, and certain private parties, and his comments to the general public, present more difficult questions. Although we identify several considerations pertinent to classifying those allegations and determining whether they are subject to immunity, that analysis ultimately is best left to the lower courts to perform in the first instance. Distinguishing the president's official actions from his unofficial ones can be difficult. When the president acts pursuant to constitutional and statutory authority, he takes official action to perform the functions of his office. Determining whether an action is covered by immunity thus begins with assessing the president's authority to take that action. But the breadth of the president's discretionary responsibilities under the Constitution and laws of the United States in a broad variety of areas, many of them highly sensitive, frequently makes it difficult to determine which of his innumerable functions encompassed a particular action. And some presidential conduct, for example, speaking to and on behalf of the American people, certainly can qualify as official even when not obviously connected to a particular constitutional or statutory provision. For those reasons, the immunity we have recognized extends to the outer perimeter of the president's official responsibilities, covering actions so long as they are not manifestly or palpably beyond his authority. In dividing official from unofficial conduct, courts may not inquire into the president's motives. Such an inquiry would risk exposing even the most obvious instances of official conduct to judicial examination on the mere allegation of improper purpose, thereby intruding on the Article II interests that immunity seeks to protect. Indeed, it would seriously cripple the proper and effective administration of public affairs as entrusted to the executive branch of the government if, in exercising the functions of his office, the president was under an apprehension that the motives that control his official conduct may, at any time, become the subject of inquiry. We thus rejected such inquiries in Fitzgerald. The plaintiff there contended that he was dismissed from the Air Force for retaliatory reasons. The Air Force responded that the reorganization that led to Fitzgerald's dismissal was undertaken to promote efficiency. Because under Fitzgerald's theory an inquiry into the president's motives could not be avoided, we rejected the theory, observing that inquiries of this kind could be highly intrusive. Bare allegations of malice should not suffice to subject government officials either to the costs of trial or to the burdens of broad-reaching discovery. Nor may courts deem an action unofficial merely because it allegedly violates a generally applicable law. For instance, when Fitzgerald contended that his dismissal violated various congressional statutes and thus rendered his discharge outside the outer perimeter of Nixon's duties, we rejected that contention. Otherwise, presidents would be subject to trial on every allegation that an action was unlawful, depriving immunity of its intended effect. With these principles in mind, we turn to the conduct alleged in the indictment. The indictment broadly alleges that Trump and his co-conspirators sought to overturn the legitimate results of the 2020 presidential election. It charges that they conspired to obstruct the January 6 congressional proceeding at which electoral votes are counted and certified, and the winner of the election is certified as president-elect. As part of this conspiracy, Trump and his co-conspirators allegedly attempted to leverage the Justice Department's power and authority to convince certain states to replace their legitimate electors with Trump's fraudulent slates of electors. According to the indictment, Trump met with the acting Attorney General and other senior Justice Department and White House officials to discuss investigating purported election fraud and sending a letter from the department to those states regarding such fraud. The indictment further alleges that after the acting Attorney General resisted Trump's requests, Trump repeatedly threatened to replace him. The government does not dispute that the indictment's allegations regarding the Justice Department involve Trump's use of official power. The allegations in fact plainly implicate Trump's conclusive and preclusive authority. Investigation and prosecution of crimes is a quintessentially executive function, and the executive branch has exclusive authority and absolute discretion to decide which crimes to investigate and prosecute, including with respect to allegations of election crime. The President may discuss potential investigations and prosecutions with his Attorney General and other Justice Department officials to carry out his constitutional duty to take care that the laws be faithfully executed. And the Attorney General, as head of the Justice Department, acts as the President's chief law enforcement officer who provides vital assistance to him in the performance of his constitutional duty to preserve, protect, and defend the Constitution. Investigative and prosecutorial decision-making is the special province of the executive branch, and the Constitution vests the entirety of the executive power in the President. For that reason, Trump's threatened removal of the acting Attorney General likewise implicates conclusive and preclusive presidential authority. As we have explained, the President's power to remove executive officers of the United States whom he has appointed may not be regulated by Congress or reviewed by the courts. The President's management of the executive branch requires him to have unrestricted power to remove the most important of his subordinates, such as the Attorney General, in their most important duties. The indictments, Allegations that the requested investigations were shams or proposed for an improper purpose do not divest the President of exclusive authority over the investigative and prosecutorial functions of the Justice Department and its officials, and the President cannot be prosecuted for conduct within his exclusive constitutional authority. Trump is therefore absolutely immune from prosecution for the alleged conduct involving his discussions with Justice Department officials. The indictment next alleges that Trump and his co-conspirators attempted to enlist the Vice President to use his ceremonial role at the January 6 certification proceeding to fraudulently alter the election results. In particular, the indictment alleges several conversations in which Trump pressured the Vice President to reject states' legitimate electoral votes or send them back to state legislatures for review. The government explained at oral argument that although it has not yet had to come to grips with how it would analyze Trump's interactions with the Vice President, there is support to characterize that conduct as official. Indeed, our constitutional system anticipates that the President and Vice President will remain in close contact regarding their official duties over the course of the President's term in office. These two officials are the only ones elected by the entire nation. The Constitution provides that the Vice President shall become President in the case of the removal of the President from office or of his death or resignation. It also empowers the Vice President, together with a majority of the principal officers of the executive departments, to declare the President unable to discharge the powers and duties of his office. And Article 1 of course names the Vice President as President of the Senate and gives him a tie-breaking vote. It is thus important for the President to discuss official matters with the Vice President to ensure continuity within the executive branch and to advance the President's agenda in Congress and beyond. The Vice President may in practice also serve as one of the President's closest advisors. The Office of Legal Counsel has explained that within the executive branch, the Vice President's sole function is advising and assisting the President. Indeed, the 12th Amendment was brought about to avoid the manifestly intolerable situation that occurred during the John Adams administration, when we had a President and Vice President of different parties. The President and Vice President together are the senior officials of the executive branch of government and therefore must formulate, explain, advocate, and defend policies of the President's administration. As the President's second in command, the Vice President has historically performed important functions at the will and as the representative of the President. President Woodrow Wilson's Vice President, for instance, presided over a few cabinet meetings while Wilson was in France negotiating the Treaty of Versailles after World War I. During President Franklin Roosevelt's administration, the Vice President became a regular participant in cabinet deliberations, a practice that was continued by each succeeding president. And when President Dwight Eisenhower suffered 3 major illnesses while in office, Vice President Richard Nixon consulted with the cabinet and developed a procedure for relaying important matters to the President. At the President's discretion, the Vice President may engage in activities ranging into the highest levels of diplomacy and negotiation and may do so anywhere in the world. Domestically, he may act as the President's delegate to perform any duties coextensive with the scope of the President's power of delegation. Whenever the President and Vice President discuss their official responsibilities, they engage in official conduct. Presiding over the January 6 certification proceeding at which members of Congress count the electoral votes is a constitutional and statutory duty of the Vice President. The indictment's allegations that Trump attempted to pressure the Vice President to take particular acts in connection with his role at the certification proceeding thus involve official conduct, and Trump is at least presumptively immune from prosecution for such conduct. The question then becomes whether that presumption of immunity is rebutted under the circumstances. When the Vice President presides over the January 6 certification proceeding, he does so in his capacity as President of the Senate. Despite the Vice President's expansive role of advising and assisting the President within the executive branch, the Vice President's Article I responsibility of presiding over the Senate is not an executive branch function. With respect to the certification proceeding in particular, Congress has legislated extensively to define the Vice President's role in the counting of the electoral votes, and the President plays no direct constitutional or statutory role in that process. So the government may argue that consideration of the President's communications with the Vice President concerning the certification proceeding does not pose dangers of intrusion on the authority and functions of the executive branch. At the same time, however, the President may frequently rely on the Vice President in his capacity as President of the Senate to advance the President's agenda in Congress. When the Senate is closely divided, for instance, the Vice President's tie-breaking vote may be crucial for confirming the President's nominees and passing laws that align with the President's policies. Applying a criminal prohibition to the President's conversations discussing such matters with the Vice President, even though they concern his role as President of the Senate, may well hinder the President's ability to perform his constitutional functions. It is ultimately the government's burden to rebut the presumption of immunity. We therefore remand to the District Court to assess in the first instance with appropriate input from the parties, whether a prosecution involving Trump's alleged attempts to influence the vice president's oversight of the certification proceeding in his capacity as president of the Senate, would pose any dangers of intrusion on the authority and functions of the executive branch. The indictment's remaining allegations cover a broad range of conduct. Unlike the allegations describing Trump's communications with the Justice Department and the vice president, these remaining allegations involve Trump's interactions with persons outside the executive branch, state officials, private parties, and the general public. Many of the remaining allegations, for instance, cover at great length events arising out of communications that Trump and his co-conspirators initiated with state legislators and election officials in Arizona, Georgia, Michigan, Pennsylvania, and Wisconsin regarding those states' certification of electors. Specifically, the indictment alleges that Trump and his co-conspirators attempted to convince those officials that election fraud had tainted the popular vote count in their states, and thus electoral votes for Trump's opponent needed to be changed to electoral votes for Trump. After Trump failed to convince those officials to alter their state processes, he and his co-conspirators allegedly developed a plan to marshal individuals who would have served as Trump's electors had he won the popular vote in Arizona, Georgia, Michigan, Nevada, New Mexico, Pennsylvania, and Wisconsin, and cause those individuals to make and send to the vice president and Congress false certifications that they were legitimate electors. If the plan worked, the submission of these fraudulent slates would position the vice president to open and count the fraudulent votes at the certification proceeding and set up a fake controversy that would derail the proper certification of Biden as president-elect. According to the indictment, Trump used his campaign staff to effectuate the plan. On the same day that the legitimate electors met in their respective jurisdictions to cast their votes, the indictment alleges that Trump's fraudulent electors convened sham proceedings in the 7 targeted states to cast fraudulent electoral ballots in his favor. Those ballots were mailed to the President of the Senate, the Archivist of the United States, and others. At oral argument, Trump appeared to concede that at least some of these acts, those involving private actors who helped implement a plan to submit fraudulent slates of presidential electors to obstruct the certification proceeding at the direction of Trump and a co-conspirator, entail private conduct. He later asserted, however, that asking the chairwoman of the Republican National Committee to gather electors qualifies as official conduct because the organization of alternate slates of electors is based on, for example, the historical example of President Grant as something that was done pursuant to and ancillary and preparatory to the exercise of a core presidential power. He also argued that it is absolutely an official act for the president to communicate with state officials on the integrity of a federal election. The government disagreed, contending that this alleged conduct does not qualify as official conduct but as campaign conduct. On Trump's view, the alleged conduct qualifies as official because it was undertaken to ensure the integrity and proper administration of the federal election. Of course, the president's duty to take care that the laws be faithfully executed plainly encompasses enforcement of federal election laws passed by Congress. And the president's broad power to speak on matters of public concern does not exclude his public communications regarding the fairness and integrity of federal elections simply because he is running for re-election. Similarly, the president may speak on and discuss such matters with state officials, even when no specific federal responsibility requires his communication, to encourage them to act in a manner that promotes the president's view of the public good. As the government sees it, however, these allegations encompass nothing more than Trump's private scheme with private actors. In its view, Trump can point to no plausible source of authority enabling the president to not only organize alternate slates of electors, but also cause those electors, unapproved by any state official, to transmit votes to the President of the Senate for counting at the certification proceeding, thus interfering with the votes of states' properly appointed electors. Indeed, the Constitution commits to the states the power to appoint presidential electors in such manner as the legislature thereof may direct. Article 2, Section 1's appointments power, we have said, gives the states far-reaching authority over presidential electors, absent some other constitutional constraint. By contrast, the federal government's role in appointing electors is limited. Congress may prescribe when the state-appointed electors shall meet, and it counts and certifies their votes. The president, meanwhile, plays no direct role in the process, nor does he have authority to control the state officials who do. And the framers, wary of cabal, intrigue and corruption, specifically excluded from service as electors all those who from situation might be suspected of too great devotion to the president in office. Determining whose characterization may be correct, and with respect to which conduct, requires a close analysis of the indictment's extensive and interrelated allegations. Unlike Trump's alleged interactions with the Justice Department, this alleged conduct cannot be neatly categorized as falling within a particular presidential function. The necessary analysis is instead fact-specific, requiring assessment of numerous alleged interactions with a wide variety of state officials and private persons. and the parties' brief comments at oral argument indicate that they starkly disagree on the characterization of these allegations. The concerns we noted at the outset, the expedition of this case, the lack of factual analysis by the lower courts, and the absence of pertinent briefing by the parties, thus become more prominent. We accordingly remand to the district court to determine in the first instance, with the benefit of briefing we lack, whether Trump's conduct in this area qualifies as official or unofficial. The indictment reflects these challenges. It includes only select tweets and brief snippets of the speech Trump delivered on the morning of January 6, omitting its full text or context. Whether the tweets, that speech, and Trump's other communications on January 6 involve official conduct may depend on the content and context of each. Knowing, for instance, what else was said contemporaneous to the excerpted communications, or who was involved in transmitting the electronic communications and in organizing the rally, could be relevant to the classification of each communication. This necessarily fact-bound analysis is best performed initially by the district court. We therefore remand to the district court to determine in the first instance whether this alleged conduct is official or unofficial. The essence of immunity is its possessor's entitlement not to have to answer for his conduct in court. Presidents therefore cannot be indicted based on conduct for which they are immune from prosecution. As we have explained, the indictment here alleges at least some such conduct. On remand, the district court must carefully analyze the indictment's remaining allegations to determine whether they too involve conduct for which a president must be immune from prosecution, and the parties and the district court must ensure that sufficient allegations support the indictment's charges without such conduct. The government does not dispute that if Trump is entitled to immunity for certain official acts, he may not be held criminally liable based on those acts. But it nevertheless contends that a jury could consider evidence concerning the president's official acts for limited and specified purposes, and that such evidence would be admissible to prove, for example, Trump's knowledge or notice of the falsity of his election fraud claims. That proposal threatens to eviscerate the immunity we have recognized. It would permit a prosecutor to do indirectly what he cannot do directly: invite the jury to examine acts for which a president is immune from prosecution to nonetheless prove his liability on any charge. But the Constitution deals with substance, not shadows. And the government's position is untenable in light of the separation of powers principles we have outlined. If official conduct for which the president is immune may be scrutinized to help secure his conviction, even on charges that purport to be based only on his unofficial conduct, the intended effect of immunity would be defeated. The president's immune conduct would be subject to examination by a jury on the basis of generally applicable criminal laws. Use of evidence about such conduct, even when an indictment alleges only unofficial conduct, would thereby heighten the prospect that the president's official decision-making will be distorted. The government asserts that these weighty concerns can be managed by the district court through the use of evidentiary rulings and jury instructions. But such tools are unlikely to protect adequately the president's constitutional prerogatives. Presidential acts frequently deal with matters likely to arouse the most intense feelings. Allowing prosecutors to ask or suggest that the jury probe official acts for which the president is immune would thus raise a unique risk that the jurors' deliberations will be prejudiced by their views of the president's policies and performance while in office. The prosaic tools on which the government would have courts rely are an inadequate safeguard against the peculiar constitutional concerns implicated in the prosecution of a former president. Although such tools may suffice to protect the constitutional rights of individual criminal defendants, the interests that underlie presidential immunity seek to protect not the president himself, but the institution of the presidency. Trump asserts a far broader immunity than the limited one we have recognized. He contends that the indictment must be dismissed because the impeachment judgment clause requires that impeachment and Senate conviction precede a president's criminal prosecution. The text of the clause provides little support for such an absolute immunity. It states that an impeachment judgment shall not extend further than to removal from office, and disqualification to hold and enjoy any office of honor, trust or profit under the United States. It then specifies that the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment, according to law. The clause both limits the consequences of an impeachment judgment and clarifies that notwithstanding such judgment, subsequent prosecution may proceed. By its own terms, the clause does not address whether and on what conduct a president may be prosecuted if he was never impeached and convicted. Historical evidence likewise lends little support to Trump's position. For example, Justice Story reasoned that without the clause's clarification that indictment, trial, judgment and punishment may nevertheless follow Senate conviction, it might be matter of extreme doubt whether a second trial for the same offense could be had, either after an acquittal or a conviction in the Court of Impeachments. James Wilson, who served on the committee that drafted the clause and later as a justice of this court, similarly concluded that acquittal of impeachment charges posed no bar to subsequent prosecution. And contrary to Trump's contention, Alexander Hamilton did not disagree. The Federalist Papers on which Trump relies concern the checks available against a sitting president. Hamilton noted that unlike the King of Great Britain, the president would be liable to be impeached and removed from office, and would afterwards be liable to prosecution and punishment. Hamilton did not endorse or even consider whether the impeachment judgment clause immunizes a former president from prosecution. The implication of Trump's theory is that a president who evades impeachment for one reason or another during his term in office can never be held accountable for his criminal acts in the ordinary course of law. So if a president manages to conceal certain crimes throughout his presidency, or if Congress is unable to muster the political will to impeach the president for his crimes, then they must forever remain impervious to prosecution. Impeachment is a political process by which Congress can remove a president who has committed treason, bribery, or other high crimes and misdemeanors. Transforming that political process into a necessary step in the enforcement of criminal law finds little support in the text of the Constitution or the structure of our government. The government, for its part, takes a similarly broad view, contending that the president enjoys no immunity from criminal prosecution for any action. It maintains this view despite agreeing with much of our analysis. For instance, the government does not dispute that Congress may not criminalize presidential conduct within the president's conclusive and preclusive constitutional authority, and it too accords protection to presidential conduct if subjecting that conduct to generally applicable laws would raise serious constitutional questions regarding the president's authority, or cause a possible conflict with the president's constitutional prerogatives. Indeed, the executive branch has long held that view. The Office of Legal Counsel has recognized, for instance, that a federal statute generally prohibiting appointments to any office or duty in any court of persons within certain degrees of consanguinity to the judges of such courts would, if applied to the president, infringe his power to appoint federal judges, thereby raising a serious constitutional question. So it viewed such a statute as not applying to the president. Likewise, it has narrowly construed a criminal prohibition on grassroots lobbying to avoid the constitutional issues that would otherwise arise, reasoning that the statute should not be construed to prohibit the president or executive branch agencies from engaging in a general open dialogue with the public on the administration's programs and policies. The government thus broadly agrees that the president's official acts are entitled to some degree of constitutional protection. And with respect to the allegations in the indictment before us, the government agrees that at least some of the alleged conduct involves official acts. Yet the government contends that the president should not be considered immune from prosecution for those official acts. On the government's view, as applied challenges in the course of the trial suffice to protect Article 2 interests, and review of a district court's decisions on such challenges should be deferred until after trial. If the president is instead immune from prosecution, a district court's denial of immunity would be appealable before trial. The government asserts that the robust safeguards available in typical criminal proceedings alleviate the need for pretrial review. First, it points to the Justice Department's long-standing commitment to the impartial enforcement of the law, as well as the criminal justice system's further protections, grand juries, a defendant's procedural rights during trial, and the requirement that the government prove its case beyond a reasonable doubt. Next, it contends that existing principles of statutory construction and as applied constitutional challenges adequately address the separation of powers concerns involved in applying generally applicable criminal laws to a president. Finally, the government cites certain defenses that would be available to the president in a particular prosecution, such as the public authority defense or the advice of the Attorney General. These safeguards, though important, do not alleviate the need for pretrial review. They fail to address the fact that under our system of separated powers, criminal prohibitions cannot apply to certain presidential conduct to begin with. As we have explained, when the president acts pursuant to his exclusive constitutional powers, Congress cannot, as a structural matter, regulate such actions, and courts cannot review them. And he is at least presumptively immune from prosecution for his other official actions. Questions about whether the president may be held liable for particular actions, consistent with the separation of powers, must be addressed at the outset of a proceeding. Even if the president were ultimately not found liable for certain official actions, the possibility of an extended proceeding alone may render him unduly cautious in the discharge of his official duties. Vulnerability to the burden of a trial and to the inevitable danger of its outcome would dampen the ardor of all but the most resolute. The Constitution does not tolerate such impediments to the effective functioning of government. As for the government's assurances that prosecutors and grand juries will not permit political or baseless prosecutions from advancing in the first place, those assurances are available to every criminal defendant and fail to account for the president's unique position in the constitutional scheme. We do not ordinarily decline to decide significant constitutional questions based on the government's promises of good faith. Nor do we do so today. As for the dissents, They strike a tone of chilling doom that is wholly disproportionate to what the court actually does today. Conclude that immunity extends to official discussions between the President and his Attorney General, and then remand to the lower courts to determine in the first instance whether and to what extent Trump's remaining alleged conduct is entitled to immunity. The principal dissent's starting premise, that unlike speech and debate clause immunity, no constitutional text supports presidential immunity, is one that the court rejected decades ago as unpersuasive. A specific textual basis has not been considered a prerequisite to the recognition of immunity, nor is that premise correct. True, there is no presidential immunity clause in the Constitution, but there is no separation of powers clause either. Yet that doctrine is undoubtedly carved into the Constitution's text by its 3 articles separating powers and vesting the executive power solely in the President. And the court's prior decisions have long recognized that doctrine as mandating certain presidential privileges and immunities, even though the Constitution contains no explicit provision for immunity. Neither the dissents nor the government disavow any of those prior decisions. The principal dissent then cites the impeachment judgment clause, arguing that it clearly contemplates that a former president may be subject to criminal prosecution. But that clause does not indicate whether a former president may, consistent with the separation of powers, be prosecuted for his official conduct in particular. And the assortment of historical sources the principal dissent cites are unhelpful for the same reason. As the court has previously noted, relevant historical evidence on the question of presidential immunity is of a fragmentary character. The most compelling arguments, therefore, arise from the Constitution's separation of powers and the judiciary's historic understanding of that doctrine. The court's prior admonition is evident in the principal dissent citations. Some of its cherry-picked sources do not even discuss the president in particular, and none of them indicate whether he may be prosecuted for his official conduct. The principal dissent's most compelling piece of evidence consists of excerpted statements of Charles Pinckney from an 1800 Senate debate. But those statements reflect only the now discredited argument that any immunity not expressly mentioned in the Constitution must not exist, and Pinckney is not exactly a reliable authority on the separation of powers. He went on to state on the same day that it was wrong to give the nomination of judges to the president, an opinion expressly rejected by the framers. Given the framers' desire for an energetic and vigorous president, the principal dissent's view that the Constitution they designed allows all his actions to be subject to prosecution, even the exercise of powers it grants exclusively to him, defies credulity. Unable to muster any meaningful textual or historical support, the principal dissent suggests that there is an established understanding that former presidents are answerable to the criminal law for their official acts. Conspicuously absent is mention of the fact that since the founding, no president has ever faced criminal charges, let alone for his conduct in office. And accordingly no court has ever been faced with the question of a president's immunity from prosecution. All that our nation's practice establishes on the subject is silence. Coming up short on reasoning, the dissents repeatedly level variations of the accusation that the court has rendered the president above the law. Like everyone else, the president is subject to prosecution in his unofficial capacity. But unlike anyone else, the president is a branch of government, and the Constitution vests in him sweeping powers and duties. Accounting for that reality, and ensuring that the president may exercise those powers forcefully, as the framers anticipated he would, does not place him above the law. It preserves the basic structure of the Constitution from which that law derives. The dissent's positions in the end boil down to ignoring the Constitution's separation of powers and the court's precedent and instead fear-mongering on the basis of extreme hypotheticals about a future where the president feels empowered to violate federal criminal law. The dissents overlook the more likely prospect of an executive branch that cannibalizes itself, with each successive president free to prosecute his predecessors, yet unable to boldly and fearlessly carry out his duties for fear that he may be next. For instance, Section 371, which has been charged in this case, is a broadly worded criminal statute that can cover any conspiracy for the purpose of impairing, obstructing, or defeating the lawful function of any department of government. Virtually every president is criticized for insufficiently enforcing some aspect of federal law, such as drug, gun, immigration, or environmental laws. An enterprising prosecutor in a new administration may assert that a previous president violated that broad statute. Without immunity, such types of prosecutions of ex-presidents could quickly become routine. The enfeebling of the presidency and our government that would result from such a cycle of factional strife is exactly what the framers intended to avoid. Ignoring those risks, the dissents are instead content to leave the preservation of our system of separated powers up to the good faith of prosecutors. Finally, the principal dissent finds it troubling that the court does not designate any course of conduct alleged in the indictment as private. Despite the unprecedented nature of this case, the significant constitutional questions that it raises, its expedited treatment in the lower courts and in this court, the lack of factual analysis in the lower courts, and a lack of briefing on how to categorize the conduct alleged, the principal dissent would go ahead and declare all of it unofficial. The other dissent, meanwhile, analyzes the case under comprehensive models and paradigms of its own concoction and accuses the court of providing no meaningful guidance about how to apply the new paradigm or how to categorize a president's conduct. It would have us exhaustively define every application of presidential immunity. Our dissenting colleagues exude an impressive infallibility. While their confidence may be inspiring, the court adheres to time-tested practices instead, deciding what is required to dispose of this case and remanding after reversing on a threshold question, to obtain guidance from the litigants and the court below. This case poses a question of lasting significance. When may a former president be prosecuted for official acts taken during his presidency? Our nation has never before needed an answer. But in addressing that question today, unlike the political branches and the public at large, we cannot afford to fixate exclusively, or even primarily, on present exigencies. In a case like this one, focusing on transient results may have profound consequences for the separation of powers and for the future of our republic. Our perspective must be more far-sighted, for the peculiar circumstances of the moment may render a measure more or less wise, but cannot render it more or less constitutional. Our first president had such a perspective. In his farewell address, George Washington reminded the nation that a government of as much vigor as is consistent with the perfect security of liberty is indispensable. A government too feeble to withstand the enterprises of faction, he warned, could lead to the frightful despotism of alternate domination of one faction over another, sharpened by the spirit of revenge. And the way to avoid that cycle, he explained, was to ensure that government powers remained properly distributed and adjusted. It is these enduring principles that guide our decision in this case. The president enjoys no immunity for his unofficial acts, and not everything the president does is official. The president is not above the law, but Congress may not criminalize the president's conduct in carrying out the responsibilities of the executive branch under the Constitution. And the system of separated powers designed by the framers has always demanded an energetic, independent executive. The president therefore may not be prosecuted for exercising his core constitutional powers, and he is entitled, at a minimum, to a presumptive immunity from prosecution for all his official acts. That immunity applies equally to all occupants of the Oval Office, regardless of politics, policy, or party. The judgment of the Court of Appeals for the D.C. Circuit is vacated, and the case is remanded for further proceedings consistent with this opinion. It is so ordered. Justice Thomas, concurring. Few things would threaten our constitutional order more than criminally prosecuting a former president for his official acts. Fortunately, the Constitution does not permit us to chart such a dangerous course. As the court forcefully explains, the framers deemed an energetic executive essential to the security of liberty, and our system of separated powers accordingly insulates the president from prosecution for his official acts. To conclude otherwise would hamstring the vigorous executive that our Constitution envisions. While the separation of powers may prevent us from righting every wrong, it does so in order to ensure that we do not lose liberty. I write separately to highlight another way in which this prosecution may violate our constitutional structure. In this case, the Attorney General purported to appoint a private citizen as special counsel to prosecute a former president on behalf of the United States, but I am not sure that any office for the special counsel has been established by law, as the Constitution requires. By requiring that Congress create federal offices by law, the Constitution imposes an important check against the president. He cannot create offices at his pleasure. If there is no law establishing the office that the special counsel occupies, then he cannot proceed with this prosecution. A private citizen cannot criminally prosecute anyone, let alone a former president. No former president has faced criminal prosecution for his acts while in office in the more than 200 years since the founding of our country. And that is so despite numerous past presidents taking actions that many would argue constitute crimes. If this unprecedented prosecution is to proceed, it must be conducted by someone duly authorized to do so by the American people. The lower court should thus answer these essential questions concerning the special counsel's appointment before proceeding. The Constitution sets forth how an office may be created and how it may be filled. The Appointments Clause provides, "The President shall nominate, and by and with the advice and consent of the Senate, shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law, but the Congress may by law vest the appointment of such inferior officers, as they think proper, in the President alone, in the courts of law, or in the heads of department." The constitutional process for filling an office is plain from this text. The default manner for appointing officers of the United States is nomination by the President and confirmation by the Senate. But the clause provides a limited exception for the appointment of inferior officers. Congress may by law authorize one of three specified actors to appoint inferior officers without the advice and consent of the Senate. As relevant here, a head of department, such as the Attorney General, is one such actor that Congress may authorize by law to appoint inferior officers without senatorial confirmation. Before the president or department head can appoint any officer, however, the Constitution requires that the underlying office be established by law. The Constitution itself creates some offices, most obviously that of the President and Vice President. Although the Constitution contemplates that there will be other officers of the United States, whose appointments are not herein otherwise provided for, it clearly requires that those offices shall be established by law. And, established by law refers to an office that Congress creates by statute. The limitation on the President's power to create offices grew out of the Founders' experience with the English monarchy. The king could wield significant power by both creating and filling offices as he saw fit. He was emphatically and truly styled the Fountain of Honor. He not only appoints to all offices, but can create offices. That ability to create offices raised many concerns about the king's ability to amass too much power. The king could both create a multitude of offices and then fill them with his supporters. In fact, one of the grievances raised by the American colonists in declaring their independence was that the king had erected a multitude of new offices, and sent hither swarms of officers to harass our people and eat out their substance. The founders thus drafted the Constitution with evidently a great inferiority in the power of the president, in this particular, to that of the British king. The founders broke from the monarchical model by giving the president the power to fill offices, with the Senate's approval, but not the power to create offices. They did so by imposing the constitutional requirement that new officer positions be established by law rather than through a king-like custom of the head magistrate unilaterally creating new offices. The Constitution thus gives Congress broad authority to establish and organize the executive branch. By keeping the ability to create offices out of the president's hands, the founders ensured that no president could unilaterally create an army of officer positions to then fill with his supporters. Instead, our Constitution leaves it in the hands of the people's elected representatives to determine whether new executive offices should exist. Long-standing practice from the founding to today comports with this original understanding that Congress must create offices by law. The first Congress, for instance, routinely and explicitly created offices by statute. Still today, Congress creates the offices that the executive branch may fill. For example, Congress has created several offices within the Department of Justice, including the offices of the Attorney General, Deputy Attorney General, Associate Attorney General, Solicitor General, and Assistant Attorneys General. For some agencies, Congress has also granted the agency head the power to appoint such officers and employees as are necessary to execute the functions vested in him. In the past, Congress has at times expressly created offices similar to the position now occupied by the Special Counsel. Congress created an office for a Special Counsel to investigate the Teapot Dome scandal and pursue prosecutions. And a statute provided for the appointment of an independent counsel that we addressed in Morrison v. Olson. That statute lapsed, and Congress has not since reauthorized the appointment of an independent counsel. We cannot ignore the importance that the Constitution places on who creates a federal office. To guard against tyranny, the founders required that a federal office be established by law. As James Madison cautioned, if there is any point in which the separation of the legislative and executive powers ought to be maintained with greater caution, it is that which relates to officers and offices. If Congress has not reached a consensus that a particular office should exist, the executive lacks the power to create and fill an office of his own accord. It is difficult to see how the Special Counsel has an office established by law, as required by the Constitution. When the Attorney General appointed the Special Counsel, he did not identify any statute that clearly creates such an office. Nor did he rely on a statute granting him the authority to appoint officers as he deems fit, as the heads of some other agencies have. Instead, the Attorney General relied upon several statutes of a general nature. None of the statutes cited by the Attorney General appears to create an office for the Special Counsel, and especially not with the clarity typical of past statutes used for that purpose. Sections 509 and 510 are generic provisions concerning the functions of the Attorney General and his ability to delegate authority to any other officer, employee, or agency. Section 515 contemplates an attorney specially appointed by the Attorney General under law, thereby suggesting that such an attorney's office must have already been created by some other law. As for Section 533, it provides that the Attorney General may appoint officials to detect and prosecute crimes against the United States. It is unclear whether an official is equivalent to an officer as used by the Constitution. Regardless, this provision would be a curious place for Congress to hide the creation of an office for a special counsel. It is placed in a chapter concerning the Federal Bureau of Investigation, not the separate chapters concerning U.S. attorneys or the now lapsed independent counsel. To be sure, The court gave passing reference to the cited statutes as supporting the appointment of the special prosecutor in United States v. Nixon, but it provided no analysis of those provisions' text. Perhaps there is an answer for why these statutes create an office for the special counsel. But, before this consequential prosecution proceeds, we should at least provide a fulsome explanation of why that is so. Even if the special counsel has a valid office, questions remain as to whether the Attorney General filled that office in compliance with the Appointments Clause. For example, it must be determined whether the special counsel is a principal or inferior officer. If the former, his appointment is invalid because the special counsel was not nominated by the President and confirmed by the Senate, as principal officers must be. Even if he is an inferior officer, the Attorney General could appoint him without presidential nomination and senatorial confirmation only if Congress, by law, vested the appointment in the Attorney General as a head of department. So the special counsel's appointment is invalid unless a statute created the special counsel's office and gave the Attorney General the power to fill it by law. Whether the special counsel's office was established by law is not a trifling technicality. If Congress has not reached a consensus that a particular office should exist, the executive lacks the power to unilaterally create and then fill that office. Given that the special counsel purports to wield the executive branch's power to prosecute, the consequences are weighty. Our Constitution's separation of powers, including its separation of the powers to create and fill offices, is the absolutely central guarantee of a just government and the liberty that it secures for us all. There is no prosecution that can justify imperiling it. In this case, there has been much discussion about ensuring that a president is not above the law. But, as the court explains, the president's immunity from prosecution for his official acts is the law. The Constitution provides for an energetic executive, because such an executive is essential to the security of liberty. Respecting the protections that the Constitution provides for the office of the presidency secures liberty. In that same vein, the Constitution also secures liberty by separating the powers to create and fill offices. And there are serious questions whether the Attorney General has violated that structure by creating an office of the special counsel that has not been established by law. Those questions must be answered before this prosecution can proceed. We must respect the Constitution's separation of powers in all its forms, else we risk rendering its protection of liberty a parchment guarantee. Justice Barrett, concurring in part. For reasons I explain below, I do not join Part 3 through 100 of the Court's opinion. The remainder of the opinion is consistent with my view that the Constitution prohibits Congress from criminalizing a president's exercise of core Article 2 powers and closely related conduct. That said, I would have framed the underlying legal issues differently. The Court describes the president's constitutional protection from certain prosecutions as an immunity. As I see it, that term is shorthand for two propositions. The president can challenge the constitutionality of a criminal statute as applied to official acts alleged in the indictment, and he can obtain interlocutory review of the trial court's ruling. There appears to be substantial agreement on the first point. Like the court, the dissenting justices and the special counsel all accept that some prosecutions of a president's official conduct may be unconstitutional. As for interlocutory review, our precedent recognizes that resolving certain legal issues before trial is necessary to safeguard important constitutional interests. Here, executive branch independence on matters that Article 2 assigns to the president's discretion. Properly conceived, the president's constitutional protection from prosecution is narrow. The court leaves open the possibility that the Constitution forbids prosecuting the president for any official conduct, instructing the lower courts to address that question in the first instance. I would have answered it now. Though I agree that a president cannot be held criminally liable for conduct within his conclusive and preclusive authority and closely related acts, the Constitution does not vest every exercise of executive power in the president's sole discretion. Congress has concurrent authority over many government functions, and it may sometimes use that authority to regulate the president's official conduct, including by criminal statute. Article 2 poses no barrier to prosecution in such cases. I would thus assess the validity of criminal charges predicated on most official acts, i.e., those falling outside of the president's core executive power, in two steps. The first question is whether the relevant criminal statute reaches the president's official conduct. Not every broadly worded statute does. For example, Section 956 covers conspiracy to murder in a foreign country and does not expressly exclude the president's decision to, say, order a hostage rescue mission abroad. The underlying murder statute, however, covers only unlawful killings. The Office of Legal Counsel has interpreted that phrase to reflect a public authority exception for official acts involving the military and law enforcement. I express no view about the merits of that interpretation, but it shows that the threshold question of statutory interpretation is a non-trivial step. If the statute covers the alleged official conduct, The prosecution may proceed only if applying it in the circumstances poses no danger of intrusion on the authority and functions of the executive branch. On remand, the lower courts will have to apply that standard to various allegations involving the president's official conduct. Some of those allegations raise unsettled questions about the scope of Article 2 power, but others do not. For example, the indictment alleges that the president asked the Arizona House Speaker to call the legislature into session to hold a hearing about election fraud claims. The president has no authority over state legislatures or their leadership, so it is hard to see how prosecuting him for crimes committed when dealing with the Arizona House Speaker would unconstitutionally intrude on executive power. This two-step analysis, considering first whether the statute applies and then whether its application to the particular facts is constitutional, is similar to the approach that the special counsel presses in this court. It is also our usual approach to considering the validity of statutes in situations raising a constitutional question. An important difference in this context is that the president is entitled to an interlocutory appeal of the trial court's ruling. A criminal defendant in federal court normally must wait until after trial to seek review of the trial court's refusal to dismiss charges. But where trial itself threatens certain constitutional interests, we have treated the trial court's resolution of the issue as a final decision for purposes of appellate jurisdiction. The present circumstances fall squarely within our precedent authorizing interlocutory review. When a president moves to dismiss an indictment on Article 2 grounds, he makes no challenge whatsoever to the merits of the charge against him. He instead contests whether the Constitution allows Congress to criminalize the alleged conduct, a question that is collateral to, and separable from his guilt or innocence. Moreover, the president's executive branch authority would be significantly undermined if appellate review of the constitutional challenge were postponed until after conviction and sentence. The prospect of a trial court erroneously allowing the prosecution to proceed poses a unique danger to the independence of the executive branch. As the court explains, the possibility that the president will be made to defend his official conduct before a jury after he leaves office could distort his decisions while in office. These Article 2 concerns do not insulate the president from prosecution, but they do justify interlocutory review of the trial court's final decision on the president's as-applied constitutional challenge. I understand most of the court's opinion to be consistent with these views. I do not join Part 3 through 100, however, which holds that the Constitution limits the introduction of protected conduct as evidence in a criminal prosecution of a president, beyond the limits afforded by executive privilege. I disagree with that holding. On this score, I agree with the dissent. The Constitution does not require blinding juries to the circumstances surrounding conduct for which presidents can be held liable. Consider a bribery prosecution, a charge not at issue here but one that provides a useful example. The federal bribery statute forbids any public official to seek or accept a thing of value for or because of any official act. The Constitution, of course, does not authorize a president to seek or accept bribes, so the government may prosecute him if he does so. Yet excluding from trial any mention of the official act connected to the bribe would hamstring the prosecution. To make sense of charges alleging a quid pro quo, the jury must be allowed to hear about both the quid and the quo, even if the quo, standing alone, could not be a basis for the president's criminal liability. I appreciate the court's concern that allowing into evidence official acts for which the president cannot be held criminally liable may prejudice the jury, but the rules of evidence are equipped to handle that concern on a case-by-case basis. Most importantly, a trial court can exclude evidence of the president's protected conduct if its probative value is substantially outweighed by a danger of unfair prejudice or confusing the issues. The balance is more likely to favor admitting evidence of an official act in a bribery prosecution, for instance, than one in which the protected conduct has little connection to the charged offense. And if the evidence comes in, the trial court can instruct the jury to consider it only for lawful purposes. I see no need to depart from that familiar and time-tested procedure here. The Constitution does not insulate presidents from criminal liability for official acts, but any statute regulating the exercise of executive power is subject to a constitutional challenge. A criminal statute is no exception. Thus, a president facing prosecution may challenge the constitutionality of a criminal statute as applied to official acts alleged in the indictment. If that challenge fails, however, he must stand trial. Justice Sotomayor, with whom Justice Kagan and Justice Jackson join, dissenting. Today's decision to grant former presidents criminal immunity reshapes the institution of the presidency. It makes a mockery of the principle, foundational to our Constitution and system of government, that no man is above the law. Relying on little more than its own misguided wisdom about the need for bold and unhesitating action by the president, the court gives former President Trump all the immunity he asked for and more. Because our Constitution does not shield a former president from answering for criminal and treasonous acts, I dissent. The indictment paints a stark portrait of a president desperate to stay in power. In the weeks leading up to January 6, 2021, Then President Trump allegedly spread lies that there had been outcome-determinative fraud in the election, and that he had actually won, despite being notified repeatedly by his closest advisors that his claims were untrue. When dozens of courts swiftly rejected these claims, Trump allegedly pushed officials in certain states to ignore the popular vote, disenfranchise millions of voters, dismiss legitimate electors, and ultimately, cause the ascertainment of and voting by illegitimate electors in his favor. It is alleged that he went so far as to threaten one state election official with criminal prosecution if the official did not find 11,780 votes Trump needed to change the election result in that state. When state officials repeatedly declined to act outside their legal authority and alter their state election processes, Trump and his co-conspirators purportedly developed a plan to disrupt and displace the legitimate election certification process by organizing fraudulent slates of electors. As the date of the certification proceeding neared, Trump allegedly also sought to use the power and authority of the Justice Department to bolster his knowingly false claims of election fraud by initiating sham election, crime investigations and sending official letters falsely claiming that the Justice Department had identified significant concerns that may have impacted the election outcome, while falsely presenting the fraudulent electors as a valid alternative to the legitimate electors. When the department refused to do as he asked, Trump turned to the vice president. Initially, he sought to persuade the vice president to use his ceremonial role at the January 6 certification proceeding to fraudulently alter the election results. When persuasion failed, he purportedly attempted to use a crowd of supporters that he had gathered in Washington, D.C., to pressure the vice president to fraudulently alter the election results. Speaking to that crowd on January 6, Trump falsely claimed that, based on fraud, the vice president could alter the outcome of the election results. When this crowd then violently attacked the Capitol and halted the proceeding, Trump allegedly delayed in taking any step to rein in the chaos he had unleashed. Instead, in a last desperate ploy to hold on to power, he allegedly attempted to exploit the violence and chaos at the Capitol by pressuring lawmakers to delay the certification of the election and ultimately declare him the winner. That is the backdrop against which this case comes to the court. The court now confronts a question it has never had to answer in the nation's history: whether a former president enjoys immunity from federal criminal prosecution. The majority thinks he should, and so it invents an atextual, ahistorical, and unjustifiable immunity that puts the president above the law. The majority makes three moves that, in effect, completely insulate presidents from criminal liability. First, the majority creates absolute immunity for the president's exercise of core constitutional powers. This holding is unnecessary on the facts of the indictment, and the majority's attempt to apply it to the facts expands the concept of core powers beyond any recognizable bounds. In any event, it is quickly eclipsed by the second move, which is to create expansive immunity for all official acts. Whether described as presumptive or absolute, under the majority's rule, a president's use of any official power for any purpose, even the most corrupt, is immune from prosecution. That is just as bad as it sounds, and it is baseless. Finally, the majority declares that evidence concerning acts for which the president is immune can play no role in any criminal prosecution against him. That holding, which will prevent the government from using a president's official acts to prove knowledge or intent in prosecuting private offenses, is nonsensical. Argument by argument, the majority invents immunity through brute force. Under scrutiny, its arguments crumble. To start, the majority's broad official acts immunity is inconsistent with text, history, and established understandings of the president's role. Moreover, it is deeply wrong, even on its own functionalist terms. Next, the majority's core immunity is both unnecessary and misguided. Furthermore, the majority's illogical evidentiary holding is unprecedented. Finally, this majority's project will have disastrous consequences for the presidency and for our democracy. The main takeaway of today's decision is that all of a president's official acts, defined without regard to motive or intent, are entitled to immunity that is at least presumptive and quite possibly absolute. Whenever the president wields the enormous power of his office, the majority says, the criminal law, at least presumptively, cannot touch him. This official acts immunity has no firm grounding in constitutional text, history, or precedent. Indeed, those standard grounds for constitutional decision-making all point in the opposite direction. No matter how you look at it, the majority's official acts immunity is utterly indefensible. The majority calls for a careful assessment of the scope of presidential power under the Constitution. For the majority, that careful assessment does not involve the Constitution's text. I would start there. The Constitution's text contains no provision for immunity from criminal prosecution for former presidents. Of course, the silence of the Constitution on this score is not dispositive. Insofar as the majority rails against the notion that a specific textual basis is required, it is attacking an argument that has not been made here. The omission in the text of the Constitution is worth noting, however, for at least three reasons. First, The framers clearly knew how to provide for immunity from prosecution. They did provide a narrow immunity for legislators in the speech or debate clause. They did not extend the same or similar immunity to presidents. Second, some state constitutions at the time of the framing specifically provided express criminal immunities to sitting governors. The framers chose not to include similar language in the Constitution to immunize the president. If the framers had wanted to create some constitutional privilege to shield the president from criminal indictment, they could have done so. They did not. Third, insofar as the Constitution does speak to this question, it actually contemplates some form of criminal liability for former presidents. The majority correctly rejects Trump's argument that a former president cannot be prosecuted unless he has been impeached by the House and convicted by the Senate for the same conduct. The majority ignores, however, that the impeachment judgment clause cuts against its own position. That clause presumes the availability of criminal process as a backstop by establishing that an official impeached and convicted by the Senate shall nevertheless be liable and subject to indictment, trial, judgment, and punishment, according to law. That clause clearly contemplates that a former president may be subject to criminal prosecution for the same conduct that resulted, or could have resulted, in an impeachment judgment, including conduct such as bribery, which implicates official acts almost by definition. Aware of its lack of textual support, the majority points out that this court has recognized presidential immunities and privileges rooted in the constitutional tradition of the separation of powers and supported by our history. That is true, as far as it goes. Nothing in our history, however, supports the majority's entirely novel immunity from criminal prosecution for official acts. The historical evidence that exists on presidential immunity from criminal prosecution cuts decisively against it. For instance, Alexander Hamilton wrote that former presidents would be liable to prosecution and punishment in the ordinary course of law. For Hamilton, that was an important distinction between the King of Great Britain, who was sacred and inviolable, and the President of the United States, who would be amenable to personal punishment and disgrace. In contrast to the king, the president should be subject to personal responsibility for his actions, standing upon no better ground than a governor of New York, and upon worse ground than the governors of Maryland and Delaware, whose state constitutions gave them some immunity. At the Constitutional Convention, James Madison, who was aware that some state constitutions provided governors immunity, proposed that the convention consider what privileges ought to be allowed to the executive. There is no record of any such discussion. Delegate Charles Pinckney later explained that the convention which formed the Constitution well knew that no subject had been more abused than privilege, and so it determined to limit privilege to what was necessary, and no more. No privilege was intended for the executive. Other commentators around the time of the founding observed that federal officials had no immunity from prosecution, drawing no exception for the president. James Wilson recognized that federal officers who use their official powers to commit crimes may be tried by their country, and if their criminality is established, the law will punish. A grand jury may present, a petty jury may convict, and the judges will pronounce the punishment. A few decades later, Justice Story evinced the same understanding. He explained that, when a federal official commits a crime in office, it is indispensable that provision should be made, that the common tribunals of justice should be at liberty to entertain jurisdiction of the offense, for the purpose of inflicting the common punishment applicable to unofficial offenders. Without a criminal trial, he explained, the grossest official offenders might escape without any substantial punishment, even for crimes which would subject their fellow citizens to capital punishment. This historical evidence reinforces that, from the very beginning, the presumption in this nation has always been that no man is free to flout the criminal law. The majority fails to recognize or grapple with the lack of historical evidence for its new immunity. With nothing on its side of the ledger, the most the majority can do is claim that the historical evidence is awash. It claims that the court previously has described the relevant historical evidence on the question of presidential immunity as fragmentary and not worthy of consideration. Yet the court has described only the evidence regarding the president's immunity from damages liability as fragmentary. Moreover, far from dismissing that evidence as irrelevant, the court was careful to note that the best historical evidence clearly supported the immunity from damages liability that it recognized, and it relied in part on that historical evidence to overcome the lack of any textual basis for its immunity. The majority ignores this reliance. It seems history matters to this court only when it is convenient. Our country's history also points to an established understanding, shared by both presidents and the Justice Department, that former presidents are answerable to the criminal law for their official acts. Consider Watergate, for example. After the Watergate tapes revealed President Nixon's misuse of official power to obstruct the Federal Bureau of Investigation's investigation of the Watergate burglary, President Ford pardoned Nixon. Both Ford's pardon and Nixon's acceptance of the pardon necessarily rested on the understanding that the former president faced potential criminal liability. Subsequent special counsel and independent counsel investigations have also operated on the assumption that the government can criminally prosecute former presidents for their official acts, where they violate the criminal law. Indeed, Trump's own lawyers during his second impeachment trial assured senators that declining to impeach Trump for his conduct related to January 6 would not leave him in any way above the law. They insisted that a former president is like any other citizen and can be tried in a court of law. Now that Trump is facing criminal charges for those acts, though, the tune has changed. Being treated like any other citizen no longer seems so appealing. In sum, the majority today endorses an expansive vision of presidential immunity that was never recognized by the founders, any sitting president, the executive branch, or even President Trump's lawyers, until now. Settled understandings of the Constitution are of little use to the majority in this case, and so it ignores them. Setting aside this evidence, the majority announces that former presidents are absolutely, or at least, presumptively, immune from criminal prosecution for all of their official acts. The majority purports to keep us in suspense as to whether this immunity is absolute or presumptive, but it quickly gives up the game. It explains that, at a minimum, the president must be immune from prosecution for an official act unless the government can show that applying a criminal prohibition to that act would pose no dangers of intrusion on the authority and functions of the executive branch. No dangers, none at all. It is hard to imagine a criminal prosecution for a president's official acts that would pose no dangers of intrusion on presidential authority in the majority's eyes. Nor should that be the standard. Surely some intrusions on the executive may be justified by an overriding need to promote objectives within the constitutional authority of Congress. Other intrusions may be justified by the primary constitutional duty of the judicial branch to do justice in criminal prosecutions. According to the majority, however, any incursion on executive power is too much. When presumptive immunity is this conclusive, the majority's indecision as to whether official acts immunity must be absolute or whether, instead, presumptive immunity is sufficient, hardly matters. Maybe some future opinion of this court will decide that presumptive immunity is sufficient, and replace the majority's ironclad presumption with one that makes the difference between presumptive and absolute immunity meaningful. Today's court, however, has replaced a presumption of equality before the law with a presumption that the president is above the law for all of his official acts. Quick on the heels of announcing this astonishingly broad official acts immunity, the majority assures us that a former president can still be prosecuted for unofficial acts. Of course he can. No one has questioned the ability to prosecute a former president for unofficial, otherwise known as private, acts. Even Trump did not claim immunity for such acts and, as the majority acknowledges, such an immunity would be impossible to square with previous decisions. This unremarkable proposition is no real limit on today's decision. It does not hide the majority's embrace of the most far-reaching view of presidential immunity on offer. In fact, the majority's dividing line between official and unofficial conduct narrows the conduct considered unofficial almost to a nullity. It says that whenever the president acts in a way that is not manifestly or palpably beyond his authority, he is taking official action. It then goes a step further. In dividing official from unofficial conduct, courts may not inquire into the president's motives. It is one thing to say that motive is irrelevant to questions regarding the scope of civil liability, but it is quite another to make it irrelevant to questions regarding criminal liability. Under that rule, any use of official power for any purpose, even the most corrupt purpose indicated by objective evidence of the most corrupt motives and intent, remains official and immune. Under the majority's test, if it can be called a test, the category of presidential action that can be deemed unofficial is destined to be vanishingly small. Ultimately, the majority pays lip service to the idea that the president, charged with enforcing federal criminal laws, is not above them, but it then proceeds to place former presidents beyond the reach of the federal criminal laws for any abuse of official power. So how does the majority get to its rule? With text, history, and established understanding all weighing against it, the majority claims just one arrow in its quiver, the balancing test in a prior case. Yet even that test cuts against it. The majority concludes that official acts immunity is required to safeguard the independence and effective functioning of the executive branch. By rejecting that branch's own protestations that such immunity is not at all required and would in fact be harmful. In doing so, it decontextualizes earlier language, ignores important qualifications, and reaches a result that the previous court never would have countenanced. In that case, the plaintiff sued a former president for money damages. He claimed that, while in office, the president had been involved in unlawfully firing him from his government job. The question for the court was whether a former president had immunity from such a civil suit. The court explained that it was settled law that the separation of powers doctrine does not bar every exercise of jurisdiction over the President of the United States. To determine whether a particular type of suit against a president, or former president, could be heard, A court must balance the constitutional weight of the interest to be served against the dangers of intrusion on the authority and functions of the executive branch. The court explained that, when judicial action is needed to serve broad public interests, as when the court acts, not in derogation of the separation of powers, but to maintain their proper balance, or to vindicate the public interest in an ongoing criminal prosecution, the exercise of jurisdiction has been held warranted. On the facts before it, the court concluded that a merely private suit for damages based on a president's official acts did not serve those interests. The court reasoned that the visibility of the president's office and the effect of his actions on countless people made him an easy target for civil suits that frequently could distract him from his public duties. The public interest in such private civil suits, the court concluded, was comparatively weak. Therefore, the court held that a former president was immune from such suits. In the context of a federal criminal prosecution of a former president, however, the danger to the functioning of the executive branch is much reduced. Further, as every member of the earlier court acknowledged, the public interest in a criminal prosecution is far weightier. Applying the balancing test here should yield the opposite result. Instead, the majority elides any difference between civil and criminal immunity, granting Trump the same immunity from criminal prosecution that Nixon enjoyed from an unlawful termination suit. That is plainly wrong. The majority relies almost entirely on its view of the danger of intrusion on the executive branch, to the exclusion of the other side of the balancing test. Its analysis rests on a questionable conception of the president as incapable of navigating the difficult decisions his job requires while staying within the bounds of the law. It also ignores the fact that he receives robust legal advice on the lawfulness of his actions. The majority says that the danger posed by criminally prosecuting a former president for official conduct is akin to, indeed greater than, what led us to recognize absolute presidential immunity from civil damages liability, that the president would be chilled from taking the bold and unhesitating action required of an independent executive. It is of course important that the president be able to deal fearlessly and impartially with the duties of his office. If every action the president takes exposes him personally to vexatious private litigation, the possibility of hamstringing presidential decision-making is very real. Yet there are many facets of criminal liability that make it less likely to chill presidential action than the threat of civil litigation. First, in terms of probability, the threat of criminal liability is much smaller. In Fitzgerald, the threat of vexatious civil litigation loomed large. The court observed that, given the visibility of his office and the effect of his actions on countless people, the president would be an easily identifiable target for suits for civil damages. Although the effect of the president's actions on countless people could result in untold numbers of private plaintiffs suing for damages based on any number of presidential acts in the civil context, the risk in the criminal context is only that a former president may face one federal prosecution, in one jurisdiction, for each criminal offense allegedly committed while in office. The majority's bare assertion that the burden of exposure to federal criminal prosecution is more limiting to a president than the burden of exposure to civil suits does not make it true, and it is not persuasive. Second, federal criminal prosecutions require robust procedural safeguards not found in civil suits. The criminal justice system has layers of protections that filter out insubstantial legal claims, whereas civil litigation lacks analogous checks. To start, Justice Department policy requires scrupulous and impartial prosecution, founded on both the facts and the law. The grand jury provides an additional check on felony prosecutions, acting as a buffer or referee between the government and the people, to ensure that the charges are well-founded. If the prosecution makes it past the grand jury, then the former president still has all the protections our system provides to criminal defendants. If the former president has an argument that a particular statute is unconstitutional as applied to him, then he can move to dismiss the charges on that ground. Indeed, a former president is likely to have legal arguments that would be unavailable to the average criminal defendant. For example, he may be able to rely on a public authority exception from particular criminal laws, or an advice of the Attorney General defense. If the case nonetheless makes it to trial, the government will bear the burden of proving every element of the alleged crime beyond a reasonable doubt to a unanimous jury of the former president's fellow citizens. If the government manages to overcome even that significant hurdle, then the former president can appeal his conviction, and the appellate review of his claims will be particularly meticulous. He can ultimately seek this court's review, and if past practice, including in this case, is any indication, he will receive it. In light of these considerable protections, the majority's fear that bare allegations of malice would expose former presidents to trial and conviction is unfounded. Bare allegations of malice would not make it out of the starting gate. Although a private civil action may be brought based on little more than intense feelings, a federal criminal prosecution is made of firmer stuff. Certainly there has been, on occasion, great feelings of animosity between incoming and outgoing presidents over the course of our country's history. Yet it took allegations as grave as those at the center of this case to have the first federal criminal prosecution of a former president. That restraint is telling. Third, because of long-standing interpretations by the executive branch, every sitting president has so far believed himself under the threat of criminal liability after his term in office and nevertheless boldly fulfilled the duties of his office. The majority insists that the threat of criminal sanctions is more likely to distort presidential decision-making than the potential payment of civil damages. If that is right, then that distortion has been shaping presidential decision-making since the earliest days of the Republic. Although it makes sense to avoid diversion of the president's attention during the decision-making process with needless worry, one wonders why requiring some small amount of his attention, or his legal advisor's attention, to go towards complying with federal criminal law is such a great burden. If the president follows the law that he must take care to execute, he has not been rendered unduly cautious. Some amount of caution is necessary, after all. It is a far greater danger if the president feels empowered to violate federal criminal law, buoyed by the knowledge of future immunity. I am deeply troubled by the idea, inherent in the majority's opinion, that our nation loses something valuable when the president is forced to operate within the confines of federal criminal law. So what exactly is the majority worried about deterring when it expresses great concern for the deterrent effect that the threat of trial, judgment, and imprisonment would pose? It cannot possibly be the deterrence of acts that are truly criminal, nor does it make sense for the majority to wring its hands over the possibility that presidents might stop and think carefully before taking action that borders on criminal. Instead, the majority's main concern could be that presidents will be deterred from taking necessary and lawful action by the fear that their successors might pin them with a baseless criminal prosecution. A prosecution that would almost certainly be doomed to fail, if it even made it out of the starting gate. The court should not have so little faith in this nation's presidents. As this court has said before in the context of criminal proceedings, the chance that now and then there may be found some timid soul who will take counsel of his fears and give way to their repressive power is too remote and shadowy to shape the course of justice. The concern that countless, and baseless, civil suits would hamper the executive may have been justified in Fitzgerald, but a well-founded federal criminal prosecution poses no comparable danger to the functioning of the executive branch. At the same time, the public interest in a federal criminal prosecution of a former president is vastly greater than the public interest in a private individual's civil suit. All 9 justices in Fitzgerald explicitly recognized that distinction. The 5-justice majority noted that there was a greater public interest in criminal prosecutions than in actions for civil damages. Chief Justice Berger's concurrence accordingly emphasized that the majority's immunity was limited to civil damages claims, rather than criminal prosecution. The 4 dissenting justices agreed that a contention that the president is immune from criminal prosecution in the courts, if ever made, would not be credible. At the very least, the Fitzgerald court did not expect that its balancing test would lead to the same outcome in the criminal context. The public's interest in prosecution is transparent. A federal prosecutor herself acts on behalf of the United States. Even the majority acknowledges that the federal criminal laws seek to redress a wrong to the public as a whole, not just a wrong to the individual, such that there is a compelling public interest in fair and effective law enforcement. Indeed, our historic commitment to the rule of law is nowhere more profoundly manifest than in our view that guilt shall not escape or innocence suffer. The public interest in criminal prosecution is particularly strong with regard to officials who are granted some degree of civil immunity because of their duties. It is in those cases where the public can see that officials exercising power under public trust remain on equal footing with their fellow citizens under the criminal law. The public interest in the federal criminal prosecution of a former president alleged to have used the powers of his office to commit crimes may be greater still. The president represents all the voters in the nation, and his powers are given by the people under our Constitution. When presidents use the powers of their office for personal gain or as part of a criminal scheme, every person in the country has an interest in that criminal prosecution. The majority overlooks that paramount interest entirely. Finally, the question of federal criminal immunity for a former president involves a countervailing Article 2 consideration absent in Fitzgerald. Recognizing such an immunity would frustrate the executive branch's enforcement of the criminal law. The president is, of course, entrusted with supervisory and policy responsibilities of utmost discretion and sensitivity. One of the most important is enforcement of federal law, as it is the president who is charged constitutionally to take care that the laws be faithfully executed. The majority seems to think that allowing former presidents to escape accountability for breaking the law while disabling the current executive from prosecuting such violations somehow respects the independence of the executive. It does not. Rather, it diminishes that independence, exalting occupants of the office over the office itself. There is a twisted irony in saying, as the majority does, that the person charged with taking care that the laws be faithfully executed can break them with impunity. In the case before us, The public interest and countervailing Article 2 interest are particularly stark. The public interest in this criminal prosecution implicates both the executive branch's interest in upholding presidential elections and vesting power in a new president under the Constitution, as well as the voters' interest in democratically selecting their president. It also, of course, implicates Congress's own interest in regulating conduct through the criminal law. Yet the majority believes that a president's anxiety over prosecution overrides the public's interest in accountability and negates the interests of the other branches in carrying out their constitutionally assigned functions. It is, in fact, the majority's position that boils down to ignoring the Constitution's separation of powers. Finally, in an attempt to put some distance between its official acts immunity and Trump's requested immunity, the majority insists that Trump asserts a far broader immunity than the limited one the majority has recognized. If anything, the opposite is true. The only part of Trump's immunity argument that the majority rejects is the idea that the impeachment judgment clause requires that impeachment and Senate conviction precede a president's criminal prosecution. That argument is obviously wrong. Rejecting it, however, does not make the majority's immunity narrower than Trump's. Inherent in Trump's impeachment judgment clause argument is the idea that a former president who was impeached in the House and convicted in the Senate for crimes involving his official acts could then be prosecuted in court for those acts. By extinguishing that path to overcoming immunity, however nonsensical it might be, the majority arrives at an official acts immunity even more expansive than the one Trump argued for. On the majority's view, but not Trump's, a former president whose abuse of power was so egregious and so offensive even to members of his own party that he was impeached in the House and convicted in the Senate still would be entitled to at least presumptive criminal immunity for those acts. Separate from its official acts immunity, the majority recognizes absolute immunity for conduct within the president's exclusive sphere of constitutional authority. Feel free to skip over those pages of the majority's opinion. With broad official acts immunity covering the field, this ostensibly narrower immunity serves little purpose. In any event, this case simply does not turn on conduct within the president's exclusive sphere of constitutional authority, and the majority's attempt to apply a core immunity of its own making expands the concept of core constitutional powers beyond any recognizable bounds. The idea of a narrow core immunity might have some intuitive appeal, in a case that actually presented the issue. If the president's power is conclusive and preclusive on a given subject, then Congress should not be able to act upon the subject. In his Youngstown concurrence, Justice Robert Jackson posited that the president's power of removal in executive agencies seemed to fall within this narrow category. Other decisions of this court indicate that the pardon power also falls in this category, as does the power to recognize foreign countries. In this case, however, the question whether a former president enjoys a narrow immunity for the exercise of his core constitutional powers has never been at issue. And for good reason. Trump was not criminally indicted for taking actions that the Constitution places in the unassailable core of executive power. He was not charged, for example, with illegally wielding the presidency's pardon power or veto power or appointment power or even removal power. Instead, Trump was charged with a conspiracy to commit fraud to subvert the presidential election. It is true that the detailed indictment in this case alleges that Trump threatened to remove an acting attorney general who would not carry out his scheme. Yet it is equally clear that the government does not seek to impose criminal liability on the president for exercising or talking about exercising the appointment and removal power. If that were the majority's concern, it could simply have said that the government cannot charge a president's threatened use of the removal power as an overt act in the conspiracy. It says much more. The core immunity that the majority creates will insulate a considerably larger sphere of conduct than the narrow core of conclusive and preclusive powers that the court previously has recognized. The gale force like first indication comes when the majority includes the president's broad duty to take care that the laws be faithfully executed among the core functions for which a former president supposedly enjoys absolute immunity. That expansive view of core power will effectively insulate all sorts of non-core conduct from criminal prosecution. Were there any question, consider how the majority applies its newly minted core immunity to the allegations in this case. It concludes that Trump is absolutely immune from prosecution for any conduct involving his discussions with Justice Department officials. That conception of core immunity expands the conclusive and preclusive category beyond recognition, foreclosing the possibility of prosecution for broad swaths of conduct. Under that view of core powers, even fabricating evidence and insisting the department use it in a criminal case could be covered. The majority's conception of core immunity sweeps far more broadly than its logic, borrowed from Youngstown, should allow. The majority tries to assuage any concerns about its made-up core immunity by suggesting that the government agrees with it. That suggestion will surprise the government. To say, as the government did, that a small core of exclusive official acts such as the pardon power, the power to recognize foreign nations, the power to veto legislation, and the power to make appointments cannot be regulated by Congress, does not suggest that the government agrees with immunizing any and all conduct conceivably related to the majority's broad array of supposedly core powers. The government in fact advised this court to leave potentially more difficult questions about the scope of any immunity that might arise on different facts for decision if they are ever presented. That would have made sense. The indictment here does not pose any threat of impermissibly criminalizing acts within the president's conclusive and preclusive authority. Perhaps for this reason, even Trump discouraged consideration of a narrower scope of immunity, claiming that such an immunity would be nearly impossible to fashion, and would certainly involve impractical line-drawing problems in every application. When forced to wade into thorny separation of powers disputes, this court's usual practice is to confine the opinion only to the very questions necessary to decision of the case. There is plenty of peril and little value in crafting a core immunity doctrine that Trump did not seek and that rightly has no application to this case. Not content simply to invent an expansive criminal immunity for former presidents, the majority goes a dramatic and unprecedented step further. It says that acts for which the president is immune must be redacted from the narrative of even wholly private crimes committed while in office. They must play no role in proceedings regarding private criminal acts. Even though the majority's immunity analysis purports to leave unofficial acts open to prosecution, its draconian approach to official acts evidence deprives these prosecutions of any teeth. If the former president cannot be held criminally liable for his official acts, those acts should still be admissible to prove knowledge or intent in criminal prosecutions of unofficial acts. For instance, the majority struggles with classifying whether a president's speech is in his capacity as president, official act, or as a candidate, unofficial act. Imagine a president states in an official speech that he intends to stop a political rival from passing legislation that he opposes, no matter what it takes to do so, official act. He then hires a private hitman to murder that political rival, unofficial act. Under the majority's rule, the murder indictment could include no allegation of the president's public admission of premeditated intent to support the mens rea of murder. That is a strange result, to say the least. The majority's extraordinary rule has no basis in law. Consider the First Amendment context. Although the First Amendment prohibits criminalizing most speech, it does not prohibit the evidentiary use of speech, including its use to prove motive or intent. Evidentiary rulings and limiting instructions can ensure that evidence concerning official acts is considered only for the proper purpose for which it was admitted. The majority has no coherent explanation as to why these protections that are sufficient in every other context would be insufficient here. It simply asserts that it would be untenable and would deprive immunity of its intended effect. The majority hazards an explanation that the use of official acts evidence will raise a unique risk that the jurors' deliberations will be prejudiced by their views of the president's policies and performance while in office. That unique risk, however, is not a product of introducing official acts evidence. It is simply the risk involved in any suit against a former president, including the private acts prosecutions the majority says it would allow. Today's decision to grant former presidents immunity for their official acts is deeply wrong. As troubling as this criminal immunity doctrine is in theory, the majority's application of the doctrine to the indictment in this case is perhaps even more troubling. In the hands of the majority, this new official acts immunity operates as a one-way ratchet. First, the majority declares all of the conduct involving the Justice Department and the Vice President to be official conduct, yet it refuses to designate any course of conduct alleged in the indictment as private, despite concessions from Trump's counsel. Trump's counsel conceded, for example, that the allegation that Trump turned to a private attorney who was willing to spread knowingly false claims of election fraud to spearhead his challenges to the election results sounds private. He likewise conceded that the allegation that Trump conspired with another private attorney who caused the filing in court of a verification signed by Trump that contained false allegations to support a challenge sounds private. Again, when asked about allegations that 3 private actors helped implement a plan to submit fraudulent slates of presidential electors to obstruct the certification proceeding, and Trump and a co-conspirator attorney directed that effort, Trump's counsel conceded the alleged conduct was private. Only the majority thinks that organizing fraudulent slates of electors might qualify as an official act of the president, or at least an act so interrelated with other allegedly official acts that it might warrant protection. If the majority's sweeping conception of official acts has any real limits, the majority is unwilling to reveal them in today's decision. Second, the majority designates certain conduct immune while refusing to recognize anything as prosecutable. It shields large swaths of conduct involving the Justice Department with immunity, but it does not give an inch in the other direction. The majority admits that the Vice President's responsibility presiding over the Senate is not an executive branch function, and it further admits that the President plays no direct constitutional or statutory role in the counting of electoral votes. Yet the Majority refuses to conclude that Trump lacks immunity for his alleged attempts to enlist the vice president to use his ceremonial role at the January 6 certification proceeding to fraudulently alter the election results. Instead, it worries that a prosecution for this conduct might make it harder for the president to use the vice president to advance his agenda in Congress. Such a prosecution, according to the majority, may well hinder the president's ability to perform his constitutional functions. Whether a prosecution for this conduct warrants immunity should have been an easy question, but the majority turns it into a debatable one. Remarkably, the majority goes further and declines to deny immunity even for the allegations that Trump organized fraudulent elector slates, pressured states to subvert the legitimate election results, and exploited violence at the Capitol to influence the certification proceedings. It is not conceivable that a prosecution for these alleged efforts to overturn a presidential election, whether labeled official or unofficial under the majority's test, would pose any dangers of intrusion on the authority and functions of the executive branch, and the majority could have said as much. Instead, it perseveres on a threshold question that should be immaterial. Looking beyond the fate of this particular prosecution, the long-term consequences of today's decision are stark. The court effectively creates a law-free zone around the president, upsetting the status quo that has existed since the founding. This new official act's immunity now lies about like a loaded weapon for any president that wishes to place his own interests, his own political survival, or his own financial gain, above the interests of the nation. The President of the United States is the most powerful person in the country, and possibly the world. When he uses his official powers in any way, under the majority's reasoning, he now will be insulated from criminal prosecution. Orders the Navy's SEAL Team 6 to assassinate a political rival? Immune? Organizes a military coup to hold on to power? Immune? Takes a bribe in exchange for a pardon? Immune? 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 Immune. Let the president violate the law. Let him exploit the trappings of his office for personal gain. Let him use his official power for evil ends. Because if he knew that he may one day face liability for breaking the law, he might not be as bold and fearless as we would like him to be. That is the majority's message today. Even if these nightmare scenarios never play out, and I pray they never do, the damage has been done. The relationship between the president and the people he serves has shifted irrevocably. In every use of official power, the president is now a king above the law. The majority's single-minded fixation on the president's need for boldness and dispatch ignores the countervailing need for accountability and restraint. The framers were not so single-minded. In the Federalist Papers, after endeavoring to show that the executive designed by the Constitution combines all the requisites to energy, Alexander Hamilton asked a separate, equally important question. Does it also combine the requisites to safety, in a Republican sense, a due dependence on the people, a due responsibility? The answer then was yes, based in part upon the president's vulnerability to prosecution in the common course of law. The answer after today is no. Never in the history of our republic has a president had reason to believe that he would be immune from criminal prosecution if he used the trappings of his office to violate the criminal law. Moving forward, however, all former presidents will be cloaked in such immunity. If the occupant of that office misuses official power for personal gain, the criminal law that the rest of us must abide will not provide a backstop. With fear for our democracy, I dissent. Justice Jackson, dissenting. Justice Sotomayor has thoroughly addressed the court's flawed reasoning and conclusion as a matter of history, tradition, law, and logic. I agree with every word of her powerful dissent. I write separately to explain, as succinctly as I can, the theoretical nuts and bolts of what, exactly, the majority has done today to alter the paradigm of accountability for presidents of the United States. I also address what that paradigm shift means for our nation moving forward. To fully appreciate the profound change the majority has wrought, one must first acknowledge what it means to have immunity from criminal prosecution. Put simply, immunity is exemption from the duties and liabilities imposed by law. In its purest form, the concept of immunity boils down to a maxim: the king can do no wrong, a notion that was firmly rejected at the birth of our republic. To say that someone is immune from criminal prosecution is to say that, like a king, he is not under the coercive power of the law, which will not suppose him capable of committing a folly, much less a crime. Thus, being immune is not like having a defense under the law. Rather, it means that the law does not apply to the immunized person in the first place. Conferring immunity therefore creates a privileged class free from liability for wrongs inflicted or injuries threatened. It is indisputable that immunity from liability for wrongdoing is the exception rather than the rule in the American criminal justice system. That is entirely unsurprising, for the very idea of immunity stands in tension with foundational principles of our system of government. It is a core tenet of our democracy that the people are the sovereign, and the rule of law is our first and final security. From their own experience and their deep reading in history, The founders knew that law alone saves a society from being rent by internecine strife or ruled by mere brute power, however disguised. A corollary to that principle sets the terms for this case. No man in this country is so high that he is above the law. No officer of the law may set that law at defiance with impunity. All the officers of the government, from the highest to the lowest, are creatures of the law, and are bound to obey it. We have long lived with the collective understanding that decency, security and liberty alike demand that government officials shall be subjected to the same rules of conduct that are commands to the citizen, for in a government of laws, existence of the government will be imperiled if it fails to observe the law scrupulously. These foundational presuppositions are reflected in a procedural paradigm of rules and accountability that operates in the realm of criminal law, what I would call an individual accountability model. The basic contours of that model are familiar, because they manifest in every criminal case. Criminal law starts with an act of the legislature, which holds the power to define a crime and ordain its punishment. Criminal statutes are laws of general applicability that express the assent of the people's representatives that certain conduct is off limits in our society. When the federal government believes that someone has run afoul of a criminal statute and decides to exercise its prosecutorial discretion to pursue punishment for that violation, it persuades a grand jury that there is probable cause to indict. Then, the government marshals evidence to prove beyond a reasonable doubt that the defendant engaged in the prohibited conduct and possessed the requisite state of mind. For his part, the defendant stands accused but is presumed innocent until conviction upon trial or guilty plea. Notably, criminal defendants have various constitutionally protected rights during the criminal liability process, including the rights to a speedy and public trial, the right to have a jury decide guilt or innocence, the right to the assistance of counsel, and the right to confront the witnesses against him. The defendant also has at his disposal many means to defend himself against the criminal charge. He can, of course, seek to hold the government to its burden of proof at trial. And even before trial, in a motion to dismiss the indictment, he might make any number of legal arguments. He can assert, for example, that the government's charging document does not give adequate notice of the charge against him, or that the law he has been accused of violating is unconstitutionally vague. He might further claim that the law is unconstitutional as applied to his particular conduct. And he might maintain that his conduct, even if proved, does not violate the law at issue. The defendant may also raise, and attempt to prove, affirmative defenses that excuse conduct that would otherwise be punishable. Generally speaking, affirmative defenses are determinations, often adopted by legislation, that certain conduct otherwise punishable by law is justified. This might be the case, for example, when the legislature determines that, under specified circumstances, the societal harm particular conduct causes is outweighed by the need to avoid an even greater harm. Importantly, a defense is not an immunity, even though a defense can likewise result in a person charged with a crime avoiding liability for his criminal conduct. Consistent with our foundational norms, the individual accountability model adheres to the presumption that the law applies to all and that everyone must follow it. Yet, the model makes allowances for recognized defenses. One such defense is the special privilege that government officials sometimes invoke when carrying out their official duties. All of this is to say that our government has long functioned under an accountability paradigm in which no one is above the law. An accused person is innocent until proven guilty, and criminal defendants may raise defenses, both legal and factual, tailored to their particular circumstances, whether they be government officials or ordinary citizens. For over 2 centuries, our nation has survived with these principles intact. With that understanding of how our system of accountability for criminal acts ordinarily functions, it becomes much easier to see that the majority's ruling in this case breaks new and dangerous ground. Departing from the traditional model of individual accountability, the majority has concocted something entirely different, a presidential accountability model that creates immunity, an exemption from criminal law, applicable only to the most powerful official in our government. So, how does this new presidential accountability model work? An initial problem is the lack of clarity regarding what this new model entails. The majority announces only its most basic contours. Instead of no immunity, the individual accountability model, or an unqualified grant of absolute immunity for all official acts, the majority purports to adopt something of a hybrid. It holds that a former president may or may not be immune from criminal prosecution for conduct undertaken while in office, to be determined on a case-by-case basis. According to the majority, whether a former president is immune depends on how his criminal conduct is classified, as among 3 possible categories. First, with respect to any criminal conduct relating to a president's core constitutional powers, those subjects within his conclusive and preclusive constitutional authority, the president is entitled to absolute immunity from criminal prosecution. Second, expanding outward from this core, regarding all other acts within the outer perimeter of the president's official responsibility, the president is entitled to at least a presumptive immunity from criminal prosecution. Third, if the criminal conduct at issue comprises unofficial acts, there is no immunity. Applying the majority's new presidential accountability model thus seems to involve bearing down on the indictment's allegations and making a series of determinations about the nature of the conduct at issue. From the structure of the paradigm, it appears that the first decision point is whether the alleged criminal conduct involves one of the president's core powers. If so, the president is absolutely immune from criminal liability for engaging in that criminal conduct. If not, then one must proceed to consider whether the conduct qualifies as an official act or unofficial act of that president. If the crime is an official act, the president is presumptively immune from criminal prosecution and punishment. But even then, immunity still hinges on whether there is any legal or factual basis for concluding that the presumption of immunity has been rebutted. Alternatively, if the charged conduct is an unofficial act, the president is not immune. The majority's multi-layered, multifaceted threshold parsing of the character of a president's criminal conduct differs from the individual accountability model in several crucial respects. For one thing, it makes it next to impossible to know ex ante when and under what circumstances a president will be subject to accountability for his criminal acts. For every allegation, courts must run this gauntlet first, no matter how well documented or heinous the criminal act might be. Thus, even a hypothetical president who admits to having ordered the assassinations of his political rivals or critics, or one who indisputably instigates an unsuccessful coup, has a fair shot at getting immunity under the majority's new presidential accountability model. That is because whether a president's conduct will subject him to criminal liability turns on the court's evaluation of a variety of factors related to the character of that particular act. Specifically, those characteristics that imbue an act with the status of official or unofficial conduct, minus motive. In the end, then, under the majority's new paradigm, whether the president will be exempt from legal liability for murder, assault, theft, fraud, or any other reprehensible and outlawed criminal act will turn on whether he committed that act in his official capacity, such that the answer to the immunity question will always and inevitably be, it depends. Under the individual accountability paradigm, the accountability analysis is markedly less convoluted, and leads to a more certain outcome. None of the same complications or consequences arise, because, as I have explained, there are no exemptions from the criminal law for any person, but every defendant can assert whatever legal arguments and defenses might be applicable under governing law. Since no one is above the law, everyone can focus on what the law demands and permits, and on what the defendant did or did not do. No one has to worry about characterizing any criminal conduct as official or unofficial in order to assess the applicability of an immunity at the outset. The majority's new presidential accountability model is also distinct insofar as it accepts as a basic starting premise that generally applicable criminal laws do not apply to everyone in our society. In the majority's view, while all other citizens of the United States must do their jobs and live their lives within the confines of criminal prohibitions, the president cannot be made to do so. He must sometimes be exempt from the law's dictates depending on the character of his conduct. Indeed, the majority holds that the president, unlike anyone else in our country, is comparatively free to engage in criminal acts in furtherance of his official duties. That point bears emphasizing. Immunity can issue for presidents under the majority's model even for unquestionably and intentionally egregious criminal behavior, regardless of the nature or the impact of the president's criminal conduct. So long as he is committing crimes pursuant to the powers invested exclusively in him by the Constitution, or as needed to carry out his constitutional duties without undue caution, he is likely to be deemed immune from prosecution. Ultimately, the majority's model simply sets the criminal law to one side when it comes to crimes allegedly committed by the president. Before accountability can be sought or rendered, the judiciary serves as a newfound special gatekeeper, charged not merely with interpreting the law but with policing whether it applies to the president at all. Also, under the new presidential accountability model, the starting presumption is that the criminal law does not apply to presidents, no matter how obviously illegal, harmful, or unacceptable a president's official behavior might be. Regardless of all that, courts must now ensure that a former president is not held accountable for any criminal conduct he engages in while he is on duty, unless his conduct consists primarily, and perhaps solely, of unofficial acts. The structure and function of the two accountability paradigms are not the only differences. The models also assign different roles to participants in the criminal justice system, and they ultimately generate different relationships between the presidency and the rule of law. Under the individual accountability model, duty-bound prosecutorial officers initially exercise their discretion to decide whether to seek punishment for alleged violations of criminal law, a determination that is made based on numerous factors. And even if prosecutors decide to bring a charge, a jury of the criminal defendant's peers ultimately determines whether that defendant, including a former president, will actually be held to account for having engaged in unlawful conduct, after the court has resolved any legal challenges and has instructed the jury as to the requirements of the law. By contrast, under the majority's new presidential accountability paradigm, what a prosecutor or jury does may not even matter, since the courts take center stage once charges are brought against a former president, marshaling their resources to conduct a complex and amorphous threshold immunity evaluation. Whether a former president will be entirely exempted from the dictates of the law, such that the roles of other participants in the criminal justice process become irrelevant, requires a judicial assessment, in the first instance, of his criminal conduct and the circumstances under which he acted. Finally, and most importantly, recall that under the individual accountability model, an indicted former president can raise an affirmative defense just like any other criminal defendant. This means that the president remains answerable to the law, insofar as he must show that he was justified in committing a criminal act while in office under the given circumstances. In other words, while the president might indeed be privileged to commit a crime in the course of his official duties, any such privilege exists only when the people, acting either through their elected representatives or as members of a jury, determine that the former president's conduct was in fact justified, notwithstanding the general criminal prohibition. Under the majority's immunity regime, by contrast, the president can commit crimes in the course of his job even under circumstances in which no one thinks he has any excuse. The law simply does not apply to him. Unlike a defendant who invokes an affirmative defense and relies on a legal determination that there was a good reason for his otherwise unlawful conduct, a former president invoking immunity relies on the premise that he can do whatever he wants, however he wants, so long as he uses his official power in doing so. In the former paradigm, the president remains subject to law. In the latter, he is above it. Justice Sotomayor has already warned of the dire consequences that are likely to follow from the majority's decision in this case. I have thus far endeavored merely to explain what today's ruling amounts to on a theoretical level: the court's abandonment of the individual accountability model as applied to presidents, and its introduction of a new presidential accountability model that authorizes the judiciary to exempt presidents from punishment under law, depending on the official or unofficial character of the criminal conduct at issue. Here, I will highlight just two observations about the results that follow from this paradigm shift. First, by changing the accountability paradigm in this fashion, the court has unilaterally altered the balance of power between the three coordinate branches of our government as it relates to the rule of law, aggrandizing power in the judiciary and the executive, to the detriment of Congress. Second, the majority's new presidential accountability model undermines the constraints of the law as a deterrent for future presidents who might otherwise abuse their power, to the detriment of us all. Consider the structural implications of today's decision from the standpoint of the separation of powers. Until now, Congress's laws, passed by the representatives of the people, bound the people and their elected officials just the same. Law, we have explained, is the only supreme power in our system of government, and every man who by accepting office participates in its functions is only the more strongly bound to submit to that supremacy, and to observe the limitations which it imposes upon the exercise of the authority which it gives. With its adoption of a paradigm that sometimes exempts the president from the dictates of the law, when the court says so, this court has effectively snatched from the legislature the authority to bind the president, or not, to Congress's mandates, and it has also thereby substantially augmented the power of both the office of the presidency and itself. As to the former, it should go without saying that the office of the presidency, the apex of the executive branch, is made significantly more powerful when the constraints of the criminal law are lifted with respect to the exercise of a president's official duties. After today's ruling, the president must still take care that the laws be faithfully executed, yet, when acting in his official capacity, he has no obligation to follow those same laws himself. But whatever additional power the majority's new presidential accountability model gives to the presidency, it gives doubly to the court itself, for the majority provides no meaningful guidance about how to apply this new paradigm or how to categorize a president's conduct. For instance, its opinion lists some examples of the core constitutional powers with respect to which the president is now entitled to absolute immunity, a list that apparently includes the removal power, the power to recognize foreign nations, and the pardon power. However, the majority does not, and likely cannot, supply any useful or administrable definition of the scope of that core. For what it's worth, the Constitution's text is no help either. Article 2 does not contain a core powers clause, so the actual metes and bounds of the core presidential powers are really anyone's guess. Nor does the majority explain how to consistently distinguish between official and unofficial acts. Quite the opposite, in fact. While acknowledging that this is a critical line that courts must draw in order for its new accountability model to work properly, the majority simultaneously cautions that making this distinction can be Difficult, likely a gross understatement given the recognized breadth of the President's discretionary responsibilities under the Constitution and laws of the United States. The majority likewise provides no guidance as to when, how, or why the President's presumptive immunity for non-core official acts might be rebutted, saying only that applying the criminal law to a President's acts must pose no dangers of intrusion on the authority and functions of the executive branch. At most, to distinguish official from unofficial conduct, the majority advises asking whether the former President's conduct was manifestly or palpably beyond his authority. But that test can be illusory, as is evidenced by the facts alleged in this very case. With respect to the indictment's allegations concerning petitioners' attempt to assemble false slates of electors in conjunction with the events of January 6, 2021, for example, the majority admits that the alleged conduct cannot be neatly categorized, and that the analysis therefore may prove to be challenging. With that, at least, I could not agree more. This much is clear. Before today, none of these kinds of inquiries was necessary for criminal liability to be fairly assessed with respect to persons accused of having engaged in criminal conduct. And frankly, none is needed now, except as relates to the President under the new paradigm the majority has crafted. Perhaps even more troubling, while Congress, the branch of our government most accountable to the people, is the entity our Constitution tasks with deciding, as a general matter, what conduct is on or off limits, the court has now arrogated that power unto itself when that question pertains to the President. In essence, the court has now imposed its own preclearance requirement on the application of Congress's laws to a former President alleged to have committed crimes while in office. Who will be responsible for drawing the crucial line between the President's personal and official affairs? To ask the question is to know the answer. A majority of this court, applying an indeterminate test, will pick and choose which laws apply to which presidents, by labeling his various allegedly criminal acts as core, official, or manifestly or palpably beyond the President's authority. Ironically then, while purportedly seeking to transcend politics, the court today displaces the independent judgments of the political branches about the circumstances under which the criminal law should apply. Effectively, the court elbows out of the way both Congress and prosecutorial authorities within the executive branch, making itself the indispensable player in all future attempts to hold former presidents accountable to generally applicable criminal laws. The framers, however, did not make the judiciary the overseer of our government. To be sure, this court may sometimes have to intervene in determining where authority lies as between the democratic forces in our scheme of government, but it has long been understood that we should be wary and humble when doing so. The majority displays no such caution or humility now. Instead, the court today transfers from the political branches to itself the power to decide when the President can be held accountable. What is left in its wake is a greatly weakened Congress, which must stand idly by as the President disregards its criminal prohibitions and uses the powers of his office to push the envelope, while choosing to follow, or not, existing laws, as he sees fit. We also now have a greatly empowered court, which can opt to allow Congress's policy judgments criminalizing conduct to stand, or not, with respect to a former president, as a matter of its own prerogative. If the structural consequences of today's paradigm shift mark a step in the wrong direction, then the practical consequences are a five-alarm fire that threatens to consume democratic self-governance and the normal operations of our government. The majority shoos away this possibility, but Justice Sotomayor makes this point plain, and I will not belabor it. Here, I will merely observe that, from a theoretical perspective, philosophers have long considered deterrence to be a key justification for adopting and maintaining systems that ensure accountability for criminal conduct. For that same reason, some commentators also maintain that decreasing the certainty of accountability for wrongful acts at least arguably reduces incentives to follow the law. Under the individual accountability model, because everyone is subject to the law, the potential of criminal liability operates as a constraint on the actions and decisions of everyone, including the President. After today, that reality is no more. Consequently, our nation has lost a substantial check on presidents who would use their official powers to commit crimes with impunity while in office. So, one might ask, what remains of accountability for presidents under law? With today's paradigm shift, the majority leaves in place only the chance that this court might someday determine that the criminal conduct in question was an unofficial act, or that the government will somehow rebut the presumption of immunity that applies to a president's official acts, such that criminal consequences might attach. But with the parameters of official and unofficial conduct unknown, I think it highly unlikely that a sitting president would feel constrained by these remote possibilities. All of this leads me to ponder why, exactly, has the majority concluded that an indeterminate core versus unofficial line drawing exercise is the better way to address potential criminal acts of a president? Could it be that the majority believes the obviously grave dangers of shifting from the individual accountability model to the presidential accountability model might nevertheless be offset by the great benefits of doing so? Some of the majority's analysis suggests as much. As far as I can tell, the majority is mostly concerned that, without immunity, presidents might be chilled from taking the bold and unhesitating action required of an independent executive. The court's opinion candidly laments that application of the law to presidents might not be even-handed, and that, as a result, presidents might be less vigorous and energetic as executive officers. But that concern ignores, or rejects, the foundational principles upon which the traditional individual accountability paradigm is based. Worse still, promoting more vigor from presidents in exercising their official duties, and, presumably, less deliberation, invites breathtaking risks in terms of harm to the American people that, in my view, far outweigh the benefits. This is not to say that the majority is wrong when it perceives that it can be cumbersome for a president to have to follow the law while carrying out his duty to enforce it. It is certainly true that a scheme of government like ours no doubt at times feels the lack of power to act with complete, all-embracing, swiftly moving authority. But any American who has studied history knows that our government was designed to have such restrictions. Our Constitution's separation of powers was adopted by the Convention of 1787, not to promote efficiency but to preclude the exercise of arbitrary power. The purpose was, not to avoid friction, but to save the people from autocracy. Having now cast the shadow of doubt over when, if ever, a former president will be subject to criminal liability for any criminal conduct he engages in while on duty, the majority incentivizes all future presidents to cross the line of criminality while in office, knowing that unless they act manifestly or palpably beyond their authority, they will be presumed above prosecution and punishment alike. But the majority also tells us not to worry, because like everyone else, the president is subject to prosecution in his unofficial capacity. This attempted reassurance is cold comfort, even setting aside the fact that the court has neglected to lay out a standard that reliably distinguishes between a president's official and unofficial conduct. Why? Because there is still manifest inequity. Presidents alone are now free to commit crimes when they are on the job, while all other Americans must follow the law in all aspects of their lives, whether personal or professional. The official versus unofficial act distinction also seems both arbitrary and irrational, for it suggests that the unofficial criminal acts of a president are the only ones worthy of prosecution. Quite to the contrary, it is when the president commits crimes using his unparalleled official powers that the risks of abuse and autocracy will be most dire. So, the fact that, unlike anyone else, the president is vested with sweeping powers and duties, actually underscores, rather than undermines, the grim stakes of setting the criminal law to the side when the president flexes those very powers. The vision John Adams enshrined in the Massachusetts Declaration of Rights, a government of laws and not of men, speaks directly to this concept. Adams characterized that document as an homage to the rule of law. It reflected both a flat rejection in positive terms of rule by fiat and a solemn promise that every act of government may be challenged by an appeal to law. Thanks to the majority, that vision and promise are likely to be fleeting in the future. From this day forward, presidents of tomorrow will be free to exercise the commander-in-chief powers, the foreign affairs powers, and all the vast law enforcement powers enshrined in Article 2 however they please, including in ways that Congress has deemed criminal, and that have potentially grave consequences for the rights and liberties of Americans. To the extent that the majority's new accountability paradigm allows presidents to evade punishment for their criminal acts while in office, the seeds of absolute power for presidents have been planted. And, without a doubt, absolute power corrupts absolutely. If one man can be allowed to determine for himself what is law, every man can. That means first chaos, then tyranny. Likewise, if the government becomes a lawbreaker, it breeds contempt for law, it invites every man to become a law unto himself, it invites anarchy. I worry that, after today's ruling, our nation will reap what this court has sown. Stated simply, the court has now declared for the first time in history that the most powerful official in the United States can, under circumstances yet to be fully determined, become a law unto himself. As we enter this uncharted territory, the people, in their wisdom, will need to remain ever attentive, consistently fulfilling their established role in our constitutional democracy, and thus collectively serving as the ultimate safeguard against any chaos spawned by this court's decision. For, like our democracy, our Constitution is the creature of their will, and lives only by their will. For my part, I simply cannot abide the majority's senseless discarding of a model of accountability for criminal acts that treats every citizen of this country as being equally subject to the law, as the rule of law requires. That core principle has long prevented our nation from devolving into despotism. Yet the court now opts to let down the guardrails of the law for one extremely powerful category of citizen. any future president who has the will to flout Congress's established boundaries. In short, America has traditionally relied on the law to keep its presidents in line. Starting today, however, Americans must rely on the courts to determine when, if at all, the criminal laws that their representatives have enacted to promote individual and collective security will operate as speed bumps to presidential action or reaction. Once self-regulating, the rule of law now becomes the rule of judges, with courts pronouncing which crimes committed by a president have to be let go and which can be redressed as impermissible. So, ultimately, this court itself will decide whether the law will be any barrier to whatever course of criminality emanates from the Oval Office in the future. The potential for great harm to American institutions and Americans themselves is obvious. The majority of my colleagues seems to have put their trust in our court's ability to prevent presidents from becoming kings through case-by-case application of the indeterminate standards of their new presidential accountability paradigm. I fear that they are wrong. But, for all our sakes, I hope that they are right. In the meantime, because the risks and power the court has now assumed are intolerable, unwarranted, and plainly antithetical to bedrock constitutional norms, I dissent. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.